a debit call from an inmate at the El Paso County Criminal Justice System.
I'm very like fashion. I'm very like fashion.
Good morning, good morning, good morning, good morning. How is everybody? Happy Monday. I hope everybody had a fantastic weekend. I had a great weekend. I watched Heretic on Max. OMG. Got to check it out. It's under the horror section, but being a true horror fan, I can tell you it's not a horror film. It's more like a thriller suspense. So don't be scared by it being in the horror genre, because it's really not a horror film. Anyway, so I also worked on my new documentary about Kai the hatchet-wielding hitchhiker. This guy, let me show you who it is. Just give me a second.
And Kai, when you're on Jen Lou's channel, what do you do with the like button?
Smash, smash, smash! Yeah.
So there you have, that's Kai, who is infamous, I will say. And oh yeah, Violet, I absolutely love A24. They just make good movies. I can't say enough good things about them. So I worked on that and hung out with my little chicken eggy pot pie Esquire that I love so much, my grandbaby. And yeah. Oh, and I had a fantastic conversation with a very, very good friend who I haven't talked to in a minute. We had a great convo, and it was the perfect end to my weekend. Also, prior to the weekend starting, Alex Erickson, and I released 2 video visits with Letitia Stout and Amy Lang from 2022. They are the last releasable video visits from prior to her trial. So they happened, Allie's was at the end of September of 2022, and mine was in October of 2022. We released them with commentary and without commentary, whichever you prefer. What else? Oh, Allie and I are waiting on some other stuff that we think you guys will enjoy if you are if you followed Letitia's trial. And I think that's all the things that I need. Oh, let me just say this. So, as you know, Allie and I covered Lori Vallow's trial together. I covered well, I mean, we were on each other's panels. So we covered Chad and Lori, okay, their trials both. And Friday night on Dateline was the interview with Lori Vallow, Daybell. I watched it Sunday. And bruh. I'm not going to give you guys any spoilers because I'm still trying to figure out a way to cover it without getting a copyright claim. And it's going to take a little bit. So I'm trying to figure out how to do that. But anywho, I'll say this and then I'm going to leave it there. It's very, very clear from that interview that Lori has an agenda. She has a reason why she finally finally they were able to. I think Lori's wanted to be on Dateline for a minute now, but she was finally able to do it, and she definitely had an agenda and a narrative to push, and that's exactly what she did. As soon as I figure out how to talk about it, maybe I'll just talk about it. Maybe I won't play clips or anything like that because if I wait long enough, like maybe, okay, the interview dropped Friday, Saturday, Sunday. Maybe what I'll do is I'll give it a week and we'll talk about it like this Friday night. That way it gives people an opportunity to watch the interview. And also, I would strongly, strongly suggest watching the channel Mormon Stories podcast. I'll get their link when I start the testimony for today. But they had a fantastic panel and they talked about it. And I really like that channel a lot. I watched it a lot during, before, during, and also after Lori and Chad's trials. And they have some incredible interviews from people who knew not Ruby Frankie, but her business partner, whose name escapes me right now because the coffee and the 5-hour haven't kicked in, but they had they have fantastic content on that. So I would absolutely, definitely go check that out. So let me say good morning to you guys, and then we will get started. Good morning, Margie. Good morning, preschool granny. Clicker, good morning. Violet, good morning. Good to see you guys. Neat Noodle, good morning. Let's see. Okay, got Jody Hildebrand. Thank you. I just heard I could not get her name. Thank you. And also to Clicker's point, and she has not aged well regarding Lori. Yeah, Lori is aging like milk. I mean, look, far be it from me to, I don't look shame typically, but Lori is I make an exception for people who are in Lori's shoes. Okay. Meaning they've murdered somebody, specifically children. Those ones are just yeah. So she, and on top of which, she's an incredibly vain woman. And let's just say that, I would imagine that at this point, the fillers are out of her system, and I'm going to leave it there. That's all I got to say about that. And also, she did show up in the Cowardly Lion hairdo, and I couldn't actually look at her the whole interview, because you can't take anybody who looks like a mix between the Cowardly Lion and a freaking Shih Tzu seriously. You just can't. Her face doesn't look like that, but her hair is done like some mix between the Cowardly Lion and a Shih Tzu. It's not a good look. I don't know who is advising you, Lori, but you need to stop. Anywho, I'm going to leave it there because this is not about that. Hey, Sarah Bellum, good to see you. Good morning. Good morning, Patricia. Good to see you. Yeah, aging like a handbag. All right. So today, what we're going to, the testimony that we're going to listen to is a digital forensic examiner. And so I would imagine he's going to be talking about the searches that were used against Todd as evidence in his original trial. Then, at the end of the day, is the his original trial attorney. So I'm looking forward to that. What am I pausing for? Clicker. Violet, I'll fight you with one hand, but tied. I can't even talk this morning. I'll fight you with one hand tied behind my back. Put 'em up. Put 'em up. I still love that movie. All right. So here we are. Let's get started. And I will go and get the Mormon Stories podcast for you guys, their channel link. And I'll just link you to the actual video, and then you can peruse their channel and the channel's content on your own accord whenever you're ready at your leisure. All right, here we go.
Okay, good morning. Are you ready to proceed, counsel?
Yes, Your Honor.
All right, you may call your first witness.
The applicant calls Sean Castle.
All right, Mr. Castle, take your time, come forward and have a seat in the chair to my left whenever you're ready. All right, raise your right hand. You swear the testimony you're about to give will be true and correct?
Yes, ma'am.
All right, microphone is on, so you should be all set. You can adjust the chair if you need to. Whenever you're ready.
Good morning, Mr. Castle.
Good morning.
Can you please state your name and spell your last for the record?
Sean Castle, K-A-S-A-L.
And Mr. Castle, what is it that you do?
I am a digital forensics expert and a network security consultant.
What?
Network security consultant.
What does that entail?
For the past 15 years, I have served as a consultant in the network security industry, specifically in the IT markets, helping dealerships build networks, telephone systems, and helping their network security posture, as well as serving as a digital forensics expert. I have spent a lot of time learning, teaching, and instructing civilians and law enforcement in the sciences behind digital forensics and network attribution.
Does this include analysis and interpretation of the digital evidence?
It does. It's the process of collecting, analyzing, and building threat reports as it pertains to evidence contained within digital devices.
So you have professional experience in digital evidence interpretation and investigation?
I do.
Can you tell me a little bit about the training you have in the area of digital forensics?
Yes. So in the industry of digital forensics, there are several software titles that we utilize on a daily basis. They are annual subscriptions for the licensing on those titles. And as a part of the renewal process, I purchased the training packages that accompany those titles from Cellbrite, Magnet Axiom, Oxygen Forensics, and Xero FTK. I also teach. I did my adjunct work at the University of Nebraska-Kearney under PhD Matt Miller, and I also am a returning guest lecturer and instructor at the Institute of World Politics in Washington, D.C., where I teach specifically in the area of network attribution and threat intelligence as it pertains to signals intelligence, social media intelligence, and open source intelligence.
So you instruct with the military?
I teach graduate students who are going to be employed by intelligence services such as CIA, NSA, and I also instruct law enforcement at the University of Nebraska-Kearney. I teach them means of correlation of data points and give them an understanding of how to build context within correlation of data. It's taking independent data points as it pertains to the evidence contained within devices, building timelines, and understanding how all of those data points come together to understand a full narrative of events or patterns.
Mr. Castle, have you provided any previous expert testimony?
I have. I have testified in state courts, federal courts, and military courts.
Have you ever been appointed as a special master?
I have. A couple instances of which I was appointed to a district court judge. The situation surrounding that was the Attorney General's office of the state of Nebraska had received privileged information and pertains to communications between their client and the attorney. So my role was to be a custodian of the data and assist the judge in parsing out that privileged information so that the AG's office could have a comprehensive report of all of the other data contained within the device.
Have you ever been disqualified as a digital forensics expert in any court proceeding?
No.
Mr. Castle, can you tell us what digital forensic evidence, what that term means?
The science of digital forensics is the ability to collect, maintain the integrity of, and analyze artifacts in digital devices such as mobile phones, tablets, computers, servers, and cloud data sources.
Are there standard operating procedures for digital forensics?
Yes, there are industry standards as defined by organizations like the National Institute of Standards and Technologies, as well as the companies who build the digital forensics tools that we use have best practices and standards for the procedural aspects of collecting, maintaining the integrity of, and doing the analysis of the data that are contained.
Would this include the investigation and interpretation of the data?
Yes.
Do you follow these standards?
Yes.
Mr. Castle, were you retained by counsel for Todd Mullis?
I was.
Just a brief pause for some fair use commentary. I see that there's a new lawyer who has entered the chat. I actually, I listened to a little bit of this before we went live, and I actually like her style. So let's see how it goes. All right, here we go.
And did you examine any electronic devices in this case?
I did.
How did you physically examine the data?
I was invited down to the Sheriff's Department in Delaware County to do my own independent collection of multiple devices on site there in September of 2022. And I also visited the Mullis family farm to collect some devices there as well. Specifically on the mobile devices, my assistant and I collected through multiple extraction processes those mobile devices to also include a network security recording device for cameras, which was located on the Mullis family farm, and also a satellite-based Dish Network TVR set-top box, and multiple laptops. I think there were 2.
What do you do first when you examine an electronic device?
Depends on the device. When it pertains to mobile devices, the first thing to do is to isolate that device from any connected network, placing it in airplane mode and making sure that Bluetooth and other similar network connectivity options are turned off, or by placing it in a Faraday cage or bag to make sure that it is unable to talk to any networks for fear of data corruption. At which point we connect those devices to the laptop or machine that we're using to extract that data and process it for further analysis. With laptops, it requires pulling the hard drives out of the laptops, connecting them to a forensic write blocker, which inhibits the ability to modify, tamper, or corrupt the data contained on that laptop, and do an image of the hard drive for further processing later. That same process is also followed with the hard drive contained within the camera security network video recorder, and as well as the set-top box for Dish Network.
Can you explain what exactly you mean by extraction?
So it is the process of collecting the data contained on the hard drive or the memory within a mobile device or laptop. There are multiple extraction methods available to a digital forensics investigator. With mobile devices specifically, there is logical, advanced logical, and physical methodologies available, both through Cellbrite and Oxygen Forensics. That process is similar in nature for both Android and Apple platform devices, and entails different methods of collecting that data within the device.
What software did you use for the phone and iPad extractions in this case?
Cellbrite UFED, which is a Cellbrite Universal Forensic Extraction Device. I actually licensed the title Cellbrite UFED for PC, which allows me to install that on one of my laptops, making it a little bit more mobile or portable as a solution.
Can you explain the 3 types of extractions through Cellbrite?
Yes. The logical extraction process is
Okay, I'm going to skip a little ahead to the actual extraction because most of us are familiar with these extractions, how they work, what they can do, what they can't do, and all of those things. So we're just going to skip ahead just a little bit because it's we don't need all that business. All right, here we go.
has spent a lot of time developing ways and means to.
Well,
I did.
You mentioned some other electronic devices. Did you do extractions for those as well?
I did.
What software did you use?
For creating the disk image of the network video recorder for the camera security system and the Dish Network for the camera security system.
Analysis?
I generated a couple of different reports. I will be specific of those. A general report of my findings overall was authored, and then I also created individual extraction reports of the data contained within the different devices that I had an opportunity to do analysis on.
I would like to show the witness what has been marked as Exhibit 272. Is it on your screen?
I do.
Do you recognize this?
This is a current copy of my Scroll Vitae, noting my professional experience, training, presentations I've done, and some of my work history.
And you mentioned this is up to date, so there's no additions?
No, I believe this is the most current version.
And can you scroll down to page 4? And what is this, Mr. Castle?
This is the first page of the report that I authored of my findings overall for this matter.
Does the CV and report, or general report, fairly and accurate represent your work and experience in this matter?
It does.
Your Honor, the applicant offers Exhibit 272.
Any objection?
Yes, Your Honor. Beyond what has been referenced, this exhibit also contains an affidavit. The report and affidavit are hearsay, and in addition to that, the report contains what this witness, essentially credibility findings of this witness, speaking about other witnesses that have testified in this case. His credibility determinations and his opinions about the truthfulness of other witnesses is inadmissible, and the report should be excluded for that reason and because it is hearsay.
Okay, this has come up a couple of times, and I'm kind of a little confused by this. Okay, so this is not the type of report that would ever make it into an actual trial if it contains these things. However, they would be required by the rules of discovery in a criminal trial to turn this over to the state, right, in its entirety. But usually when an expert is retained by defense and they do their work, the report that there's a separate report where it's just their findings that can be admitted. And what I don't understand is why the applicant, because it's not really the defense in this case, but it is. That's not how they're referred, because it's post-trial, or it's a post-conviction relief hearing, or yeah. Anywho, that's neither here nor there. What I don't understand is why they would not just use the just get in the report itself, not all of the supporting documents. Obviously you have to turn that over because of the rules of discovery, but that part I don't understand. And maybe there's an actual reason for that, and I just don't know that. Good morning, call me Sadie. So who's testifying on the stand currently is Mr. Castle. He is a digital forensic expert, and he performed searches on various electronics at the Mullis, from the Mullis house, and he's going to be testifying to that. How did your orthopedic appointment go? I hope well. You got some answers. Let me know. All right, here we go.
Would you like to respond?
Your Honor, this goes to what happened in the underlying trial, as well as the evidence that was presented, and it is a full explanation of Mr. Castle's experience and his analysis of the data that he extracted and analyzed. It's about the weight and not the admissibility of the evidence.
272 will be admitted. However, the court will not consider the affidavit portion of that exhibit or give any weight to any credibility determinations made of other individuals if they're referenced throughout the report. Certainly to the extent that counsel is utilizing the report in any questioning of the witness, I would ask that you avoid any of those portions, please. You may proceed.
Thank you, Your Honor. Did you review any depositions or trial testimony in this case?
I did.
And who would that have been of?
The testimony and trial transcripts of former deputy Travis Hemiseth and the DCI agent, Mr. Trebet.
Your Honor, I see the witness is reading from the screen. Is he reading from the report?
He is, and I can put it up on the TV if that's helpful.
Yes, put it up on the TV. That'll be very helpful. Camera person,
Did you also review the testimony and deposition?
we
of
want to
Mark
see the
Allen?
TV.
I did.
Nicole, you can take down. Did you receive and review the extraction and digital discovery evidence from Mr. Mullis's criminal trial?
I did.
Mr. Castle, did you review the iPad that belonged to the Mullis family?
I did.
What browser was used on this iPad?
Primarily the Safari web browser.
On this particular device, did the Safari web browser default to Google searches?
The Safari web browser had the Google search engine as its default search engine.
Did you review Mr. Hemseth's testimony regarding the iPad?
I did.
And do you recall that his testimony about the search history on the iPad was falling off?
I do recall that portion of his testimony.
Was this correct?
No.
And why is that?
I'm going to object. This is going into credibility determinations. He can testify about his own findings and whether, and the court can determine if they are consistent with the underlying trial testimony.
Aw, Sadie, that's a bummer. Frozen shoulder syndrome. Well, I'm glad to know that you got some answers, though, just to put your mind at ease and you can know what you're dealing with. So that's good. I hope it gets better, and I hope the shots and the physical therapy help you, babe. All right, here we go.
May I be heard, Your Honor?
Go ahead.
This is not a credibility issue. This is about the actual issues and what was actually on the iPad and the evidence that should have been presented at Mr. Mullis's trial.
Yeah, I agree. Objections overruled. Do you remember the question, sir?
Could you restate, please?
Yes. Just you were about to explain the search history of the iPad falling off.
Yes. Upon visual inspection of the device, there would be a list of most recent searches that a user had done on the device. But upon the extraction and analysis of the data contained within the iPad, it reveals a longer history or a more comprehensive understanding of all the searches that were conducted on the device.
Can you explain what it would mean for searches to be falling off?
Visual inspection of the device when tapping in the Google search area it would show the most recent searches conducted by a user of the device, and that would be a short list, just simply because the screen is only so long and it would only represent those most recent searches that were conducted. But that does not inhibit or restrict the memory of the device or the number of searches that were actually conducted on the device itself. That would be revealed upon the extraction and analysis of the data itself.
So the evidence would still, or the search history would still be available?
In two different locations, one on the device and also as a part of the subpoena offer to Google for the comprehensive search history.
Were you able to determine when the iPad was first activated?
I believe I recall that in August of 2017, the first user activity demonstrated on the device was a connectivity to a wireless network, representing the first viable activity recognized on the device in its activation time period.
Is there a way to determine how the iPad accesses the internet?
Yes, the Apple ecosphere keeps a fairly comprehensive system log that demonstrates the network traffic that leaves or arrives on the device via its network interfaces. Those network interfaces being the WWAN interface, which would be the cellular radio on the device, or the Wi-Fi radio interface for standard Wi-Fi network connectivity.
Can you have a cellular data plan on an iPad?
There are a couple different models of iPad. One of those models does contain a radio that is capable of 3G, 4G, and now more modern 5G cellular data transmissions.
Are you aware if the Mullis family iPad had a cellular data plan?
It had a radio that was capable of cellular network traffic. The time frame in which it had a data plan attached to it was determined later.
Okay. I would like to show the witness what has been marked as Exhibit 256. Mr. Castle, based on your experience in this field, is this a document that you would normally see?
Yes.
And do you often see activation plans in your work?
As a part of network threat attribution, one has to correlate multiple data points, one of those being subscriber data, to gain an understanding of the traffic that may have arrived on the device, the IP addresses associated with that traffic, and the data plans connected to them. Yes.
Your Honor, the exhibit is being displayed. This was an issue yesterday as well, where exhibits are being displayed where they haven't been admitted. Thank you.
Did you use this document to reach your opinion on whether the cellular data was activated?
It was one of the data points that I used, yes.
Counsel, and I guess I would just say, I mean, with regard to the displaying of the exhibits, again, this isn't a jury trial, and so it doesn't really matter to that end. Normally, we wouldn't want them displayed because a jury would be seeing them, but to the extent the court is the fact finder, that isn't a concern in terms of what's being seen. Obviously, we have spectators and the media viewing, so there is that, but it isn't those spectators or the media that will be the fact finder in this case. So just want to note that for the record.
And thank you, Your Honor. The one reason I point that out specifically is some of the exhibits that have been filed have unredacted personal information, social security numbers, minors' names. So if it's up before I have a chance to open the exhibit, it's difficult for me to determine.
Well, yeah, and the issue of redacting information is certainly different. There shouldn't have been anything filed with unredacted information. I think there's only been one exhibit that we've talked about that needed to be filed at a higher security level. So that is something that should be brought to my attention. So thank you for that.
Yeah. State, don't come out your hair. Was there something in this report that was there something in the exhibit that was that should have been redacted? Or are you just reminding the court that the applicant made a mistake? Yeah, petty. Here we go.
All right, go ahead, Ms. Steenson. Sorry for the interruption.
That's okay. Thank you, Your Honor. Does this appear to be an activation plan from U.S. Cellular?
Yes.
Is the phone number the phone number listed, the one associated with the Mullis family iPad?
Yes, it correlates to the telephone number represented in the Cellbrite extraction report.
And what day was this plan activated?
I believe it was October 12th of 2018.
Your Honor, the applicant offers Exhibit 256.
Any objection?
Based on prior agreements with counsel that we will not require U.S. Cellular to come in and lay foundation, I have no objection.
256 is admitted.
Mr. Castle, do you know when planting is generally is?
Objection. This is the foundation.
Right, sustained.
Were there email accounts connected to the iPad?
Yes.
Is there evidence on the iPad that links to Todd Mullis 76 Google account?
Yes.
Is there evidence on the iPad that links to Mullis RN Gmail account?
I'm sorry.
All withdraw.
Okay.
That second part of the question?
Yes. Is there evidence on the iPad that links to the Mullis RN Google account?
Yes, there are artifact evidence of both accounts on the device.
And is there evidence on the iPad that links to Amy Lynn 5810 Google account?
I did not find any artifacts or evidence of that account being linked.
Mr. Castle, you mentioned earlier that you reviewed the cell phones in this case. Did you analyze Todd Mullis's phone?
I did.
And what type of phone was this?
It was an LG older style flip phone.
During the course of your review of the digital forensic evidence, did you review Todd's U.S. cellular records?
I did.
I would like to show the witness what has been previously marked as Exhibit 373. Can you tell me what this document is?
It appears to be a phone record of a device in a billing period noted. This appears to be the phone records for Todd Mullis' phone.
Are the last 4 digits of Todd's phone number 1114?
Yes, as represented in the document.
Are these the records that you received from the state?
Yes.
The applicant offers Exhibit 373.
Any objection?
Your Honor, the only objection I have, as was stated in our preliminary objections, is there is highlighting added by Mr. Mullis' counsel on the first page of the exhibit. But beyond that, in agreement, consistent with our prior agreement about the U.S. Cellular, I have no other objection beyond that.
373 is admitted with the understanding that the highlighting, I guess, was not original to the document.
Yes, Your Honor, and I believe there has been another version filed without the highlighting in it.
Okay, thank you.
And you can take this down. During the course of review of the digital forensic evidence, did you review law enforcement's extraction of Todd's phone?
I did.
I would like to show what has been marked as Exhibit 353. What is this, Mr. Castle?
And this is a page that was a part of the extraction report of the phone, Todd's phone specifically.
And how is it that you recognize this?
First, it notates the extraction report and the model number of the device up at the top, and it was also labeled Todd's phone. And as far as the data contained within the report, it represents some sent and received communications.
The applicant offers Exhibit 353.
Any objections to 353?
Minimally, Your Honor, there's some handwriting on it. If additional foundation can be laid, just the handwriting where it says Todd's phone, etc.
Ms. Stinson?
Yes, I believe that this. Yes. Did this. Did this come from defense counsel's file?
It did. It's not my handwriting specifically on the phone that, as far as the notes on it. I recognize the report as a result of the model number of the device and the communications on it.
But this is what you received?
Yes. Minus the handwriting.
Does that address your objection, counsel?
I'm fine with it being admitted, Your Honor.
Right. Again, 353 will be admitted with the understanding that the handwriting, I guess, is not relevant necessarily to the exhibit.
Mr. Castle, did you analyze Mrs. Mullis's phone?
I did.
And what type of phone was that?
It was a smartphone with a larger screen, a more modern device.
Are the last 4 digits of the phone number 5675?
I believe so, yes.
Did this phone have access to the internet?
It did, which was in contrary to Mr. Mullis' phone, which the flip phone had internet capabilities, but there was no artifacts or evidence of any internet usage. Where on Ms. Mullis' phone, it did have a web browser that represented artifacts and evidence of web history to include social media.
Would this also included Facebook?
Yes.
So you indicated that there had been internet searches on the phone?
On Ms. Mullis's phone, yes.
Was there any email accounts connected to Mrs. Mullis's
There were multiple
phone?
accounts.
Is there evidence on the phone that links to Mullis RN Google account?
Yes.
Mullis RN Google account?
Yes, there was.
Is there evidence on the phone that links to Amy Lynn 5810 Google account?
Yes.
Is there evidence on the phone that links to Todd Mullis 76 Google account?
Yes.
Was there a recovery number on the Todd Mullis 76 Google account?
There was.
Can we get foundation for what the recovery number is?
The objection's overruled. The answer will remain in the record. Go ahead, Ms. Steenson.
Thank you. Can you tell me what a recovery number is for a Google account?
When setting up a Google account, Google wants a phone number that can be utilized to recover the account in the event of a forgotten password or a security breach, so that they can validate the identity of the user, so that they can have some means of validation that the end user is who they say they are, and have the ability to then get back into the account in the event of its lock or password forgotten scenarios.
So you would be able to reset a password for a Google account through a recovery phone number?
Yes, or offer it as a means of two-factor authentication.
So you mentioned that there was a recovery number linked to the Todd Mullis 76 Google account. Whose number was that?
It was a number associated with Ms. Mullis's phone.
Briefly on the Mullis RN Google account, did you review the search history from this Google account?
I reviewed the search history both on the device and as a part of the subpoena reply from Google.
Did you notice that the Google account included searches about cabins?
I did.
Over the course of your analysis in the forensic digital evidence of this case, did you review Mrs. Mullis's U.S. cellular phone records?
I did.
I would like to show the witness what has been previously marked as Exhibit 374. Mr. Castle, what is this?
This is a representative of some cellular communications and the telephone number associated with Ms. Mullis's phone.
And is this what you received from the state's discovery?
Yes.
I would like to admit Exhibit 374.
Any objection to 374?
No objection. Just, however, if we can clarify for the record that it's being received from the state through Mr. Mullis's counsel, but otherwise no objection.
374 is admitted with that clarification.
Mr. Castle, did you analyze Tristan Mullis's phone?
I did.
What type of phone was this?
It was also a smartphone with a larger screen or display and had internet capability and connectivity.
Were the last four digits of the phone number 1864?
I believe that to be correct, yes.
Were there internet searches on this phone?
There were multiple internet searches on the device.
And what types of searches were these?
There were searches for PC games, mobile device games, several multimedia searches, and searches for, very specifically, military sniper-style games.
And what other types of searches were there?
There was some, under the multimedia category, there were some searches for some adult-related content.
And what type of online games did you find?
World of Warships and other similar combat-style online games.
And when you say adult content, what is it that you mean?
Specifically pornography.
And were there searches for snipers?
Yes, it was one of the games that was searched for.
Did you create extraction reports of Amy and Todd's text messages?
Yes, I created an extraction report both from Todd's phone and from Ms. Mullis's phone as pertaining to the communications between those two parties.
I would like to show the witness what has been marked as Exhibit 307. Mr. Castle, what is this?
This is an extraction report of specifically SMS communications between Todd and I believe that Ms. Mullis's phone, or Ms. Mullis's messages.
And did you do this extraction report?
I believe so. The cover page is missing. That would give more detail, but from my recollection, yes, this is a report that I generated of the data extracted from the phones.
And besides the missing cover page, is this a fair and accurate representation of the data you extracted?
Yes.
I would like to admit Exhibit 307 into evidence.
Any objection?
Yes, Your Honor. I think more foundation needs to be laid about how this exhibit was created. It's been portrayed as communications and text messages between the two, but after, I believe, page 20 on my version of the exhibit that I was given, there's pictures, Facebook posts, all sorts of different things that I don't think were mentioned by the witness.
I think I heard the witness say they were SMS communications, so maybe we could have some further explanation, Ms. Steenson.
While you were analyzing Amy Mullis's phone, you had mentioned that she had Facebook on her phone. Did you analyze her Facebook account?
I did. And the reports that I generated of those devices may have contained more information than just the SMS or communications between the parties. It may have included other artifact evidence that was contained within the device for review by defense counsel.
Okay, let me just pause briefly for some fair use commentary. I know that this type of testimony is a little tedious and a little dry, okay? But it's important because, well, all evidence is important, but in this situation, it's particularly important because a lot of to-do was made about these searches, that it was Todd and Todd alone that was the most likely person who did these searches. And it's, during his original trial, it was used to substantiate that he was angry with Amy. He was aware of her affair. He felt betrayed, all the things, right? Which goes to motive, which obviously is not necessary for the state always to prove. Most of the time it's not. There are exceptions. There's always exceptions. But in this situation, it wasn't something that was required. But juries like to hear motive. And for purposes of this hearing, the reason that it's important is, had the original trial attorneys, even if they didn't go down the road that Todd wanted them to go down, which was to investigate this as an accident, certainly it would have behooved the defense to have their own analysis done of the electronics, and they didn't, and that's a problem. So also, if there are any creators that are listening but not chatting, if you have Nightbot, you have to redo everything. I don't know what happened, why it's like that, why there's an issue, but there was. My channel was not even connected to Nightbot anymore. I don't know if maybe it's because there's new permissions that are required. I don't know. But anywho, if you are having a struggle with Nightbot, you probably have to reconnect your channel, give it all the permissions, yada, 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 whatever. All right, here we go. Sadie, I don't, call me Sadie, I don't see that, but I mean, he's making the same face that he's been making the whole trial, so.
Yeah, can you talk, what page is this? Starting on page 19, can you tell us what these are?
He mainly just looks, I don't know, like he's giving his attorneys the side eye, which is part because of that's just Todd's face, but the other part of it is his location at the defense table. So, they have him situated where he can see everybody, but not really. There's a couple of the attorneys that he can't see, kind of has to side eye. I don't know, it's just, I mean, he's got kind of a stern look. It is what it is. I would advise the defense counsel, should he be granted a new trial, that they speak to him about that.
These would appear to be social media posts or the pages represented on their social media containing images and communications or posts on those media accounts.
And is this from Amy Mullis's Facebook account?
If she was slow so I can validate the, yes, this would be from the Facebook account for Ms. Mullis.
Well, this is a good question. So Violet says, Jen Lu, do you think the judge is leaning one way or another towards retrial? I can't decipher if she is annoyed with the defense or irritated at the incompetence of the witness from the first trial. I don't really have a sense at this time. We're only on day 4, which there are only six days total. So there's only 2 more days of testimony. And there was supposed to be, now I don't know how many, there were 40 people there were 40 witnesses listed. I don't know how many were actually called, but I can tell you we have had the 2 forensic, the biomechanical, his friend, the lead investigator, 5. This would be number 6. Now, I don't know if we still have 34 more witnesses to go or if they shortened it, but I get the sense that the judge from the defense wants a shorter amount of evidence that goes to the ineffective assistance of counsel. Like, obviously, there has to be foundation laid about which devices were searched, and all of that. But I think the judge would prefer it to be more to the relevant portions. For example, like with right now, the question with Facebook. Okay, was Facebook something that was brought up in the original trial? Here's how, by the state, if it was, here's the evidence that had the defense reached out to a digital forensic expert and retained a digital forensic expert to evaluate what the state did. Here's what would have been different. I think she wants it to be a little more brief. Let's see. Hold on a minute. I'm missing somebody's. All right. So I do think there should be a little. I think that the judge would like this to be a little more brief, because remember, the more evidence that's presented, it will bolster their case, right? But on the flip side of that, the more evidence that's presented, the longer it will take for the judge to go through the evidence and weigh all of it out. And, so here we go.
Is Exhibit 307 a fair and accurate representation of the SMS extraction you did and also the Facebook post from Amy Mullis's Facebook page?
Yes, this will be an extraction report of her device containing those items.
Your Honor, I would like to renew my request to admit Exhibit 307.
Any objection at this time?
Yes, Your Honor. May I briefly, while you're the witness,
You may.
clarify this? Thank you. Good morning, Mr. Castle.
Good morning, sir.
Up on your screen, do you have the Facebook messages there? Can you look at the bottom of one of those pages in the bottom right? Can you tell me what you see there?
Counsel, I think you'd probably have to identify a specific page,
Sure.
and then we'll have to have.
I'm looking at page 19. In the bottom right corner, it shows a page number. Do you see that? Once she gets there.
Also, yes, Clicker, I mentioned that earlier, that at the end of today's day 4's testimony is the beginning of the former attorney's testimony. The forensic, the digital forensic examiner is going to take just about all day.
Yes. So there is not 1,453 pages from Facebook in this document?
In this document, it would appear to be an excerpt or a extraction of specific pages within that more comprehensive report, yes.
And then if you can scroll just to, can you see the top of that page, the very top line on that, on page 19?
Which line specifically are you wanting me to look at?
So right by the e-filing stamp, is the top of that consistent with something that would be printed off Facebook, or is that something that would be consistent with coming from a Celebrite or similar type of extraction?
Can you scroll down just a little bit so I see the bottom of the page? This would appear to be part of a print of a Facebook page. This specific page, not part of the Celebrite extraction report.
Thank you. Your Honor, I would object on foundation, completeness, and relevance. These two mesh of documents are unrelated. I don't understand this exhibit.
Yeah, I guess, counsel, do you want to respond to that? It's certainly the way that the exhibit is labeled, and I guess my understanding of what the witness did, it would appear that the first 18 pages make sense. I understand how those were obtained and where they came from. The remaining portion of the exhibit does seem to be cherry-picked pages from Facebook. Can you clarify that, please?
Just one moment, Your Honor.
Sure.
So, Mr. Castle, you mentioned that you did an analysis on Mrs. Mullis's phone that included that she had a Facebook account. Is that right?
Correct.
And is it possible to download information from Facebook?
It is.
And how would that work?
There are multiple ways to acquire that data, primarily for the purposes of integrity. Facebook offers a process of a Facebook download in which they pull all the data from their multiple servers that contain account information, posts, messages, those types of things, and combine it within a single zip file that has a report of all that data the user may have posted or communicated via their social media. Secondarily, there are ways to scrape or pull individual posts and pages from Facebook from a computer. There's a couple of different processes that could have been utilized to acquire the information.
Is a portion of your report these Facebook extracts? Starting at page 19.
Objection, Your Honor. The witness has already testified that this is not an extraction. These are prints from Facebook. And I'm going to add an objection under 403 that the exhibit in its current form is misleading because the page numbers continually jump around.
This exhibit does contain a portion of the Celebrite report that I created.
Okay. I apologize, sir. Yeah. I mean, I guess I heard the witness say that these appeared to be pages that were printed from Facebook. It certainly does appear to be incomplete if we look at the page numbers at the bottom. So we're really dancing around that issue. So the objection sustained for now.
Your Honor, I would like to offer pages 1 through 18 of what has been marked as Exhibit 307, the evidence which represents the extraction of the SMS phone records.
Any objection to that portion of 307?
Yes, Your Honor, only because this gets back to my original objection with the exhibit, that I believe additional foundation for how because I believe the witness said this is coming from two different phones, so I believe additional foundation of how the messages were combined would be beneficial.
Okay. Ms. Steenson, would you like to lay some additional foundation, specifically with regard to the, I guess, combining of the information from the two phones for purposes of creating the summary on the first 18 pages of 307?
Yes, of course, Your Honor. Thank you. Mr. Castle, can you explain how you created this extraction report?
If I'm allowed to look at the previous 18 pages, I can validate Okay. This Cellbrite extraction report here specifically is from Ms. Mullis's phone, and is not a compilation of multiple devices. The first 18 pages are just the extraction report of Ms. Mullis's phone and the communications between her and Todd.
I would like to readmit or renew my request to admit Exhibit 307, pages 1 through 18.
Mr. Bakke?
No objection on that portion. Thank you.
The first 18 pages of 307 are admitted.
Mr. Castle, did you create an extraction report of Mrs. Mullis and Jerry Frazier's emails?
I created a report of the communications between those two parties, yes.
I would like to show the witness what has been marked as Exhibit 308. What is this, Mr. Castle?
It is an extraction report representing emails between the two accounts noted in the second column, Amy Lynn 510@gmail.com and Jerry Frasher 70@gmail.com.
What time period do these cover?
It appears to be November of 2018. Is there multiple pages to this document or just a single page?
Mr. Castle, can you tell us how you created this extraction?
So for this report, I chose the email communications category within the Cellbrite application and extracted that data specifically into this BASER document.
And is this a fair and accurate representation of the report that you created of the emails between Mrs. Mullis and Jerry Frazier?
As they existed on the device, specifically, yes.
I would like to request to admit Exhibit 308.
Yes, Your Honor. This was also raised in our preliminary objections. Many of these email communications, example beginning at page 3, states that the item was truncated due to length. I don't believe foundation has been laid as to that truncation of the emails. Additionally, it states that it contains body files. Those are hyperlinks that don't go to anything, so the messages appear to be incomplete.
Ms. Steenson, would you like to address those concerns, please?
Yes, thank you. Mr. Castle, can you go to page 3 of this report, please? Can you tell me what it means to have this what truncate means?
When generating the report, due to the volume of the data contained within that specific communications, it leaves the final portion of that communication off as a function of generating this report. The source data that the information was derived from is complete and in totality. This report just simply pulls the rest of the data out of it. This is more representation of that the communications between these two parties happened, and this is a overview or summary of the initial communication between the two parties.
Your Honor, I would like to renew my request to admit Exhibit 308.
Counsel?
Thank you, Your Honor. I do object. I'm going to object on 403 that in its current form, the emails, the truncated version of the emails are misleading, especially with the full content not being available for consideration. Thank you.
May I be heard, Your Honor?
You may.
The state has all of this data. This is just for, this goes to the weight, not the admissibility. We are asking for, this is just an example of it reflects what was sent between, but the state has all the underlying data, and if they want to cross Mr. Castle on this, they are willing to.
Counsel, do you agree that you have all of the underlying data that was used to create this report?
Yes, Your Honor. It's likely in the terabyte of information, or approximately terabyte of information that I've received. I don't believe it's a discovery issue. It's that the fact finder here is only getting partial. So I think if there's any specific email that needs to be referenced, it would be more appropriate for that full email to be admitted, not truncated partial summaries.
Certainly. I do think it goes to the weight to be given this particular exhibit, if any. 308 will be admitted.
Mr. Castle, can you tell me what UTC is?
is coordinated universal time code. It is a universal accepted standard for establishing a uniform way of maintaining a timestamp globally.
Is this standard in digital forensics?
It is standard in network communications as well as digital forensics, a way of establishing a baseline timekeeping methodology.
What time zone is Iowa?
Iowa is in the Central Standard Time Zone, or CDT, Central Daylight Savings Time Zone, depending upon the time of year that it is.
What is UTC time in Central Standard Time?
It is minus 6 hours from the UTC time code.
And does UTC time change with daylight savings?
UTC remains unchanged. However, the offset for Central Standard Time is adjusted by the hour.
When it is midnight in UTC, what time is it in Iowa?
Non-daylight savings time, it would be 6 p.m.
Is it typical for extractions to be in UTC time?
That's how the data contained within a mobile device is represented, is in UTC time code stamping. It is an option within the software titles to make that calculation or adjustment for Central Time or daylight savings time accordingly.
So there has to be a conversion from whatever uniform standard time is used?
Correct.
And the reviewer would have to convert to Central Standard Time or Iowa time or the relevant time zone?
The machine will automatically adjust those time code stamps accordingly, making it less prone to mistake or calculation by the end user or the analyst.
Did you review Mr. Hemes's testimony regarding UTC?
I did.
Was he correct that UTC is military time?
No.
Was he correct that UTC is Central Standard Time?
Central Standard Time is a time zone based on an offset of UTC, so no, it would not appear to be correct.
So the times and dates that Mr. Hemes testified to would be wrong?
Unless the offset was checked against the time code within the report, it would appear to be incorrect.
Mr. Castle, did you review the Dish Network DVR system?
I did.
And did you do an extraction of this electronic device?
I did.
And this is the system from the Mullis home?
It is. The satellite TV set-top box was the device I retrieved and created a disk image of to do analysis on.
So the question surrounding UTC time, that's important because in the original trial, I should say, the testimony was incorrect about the times because the lead investigator at the time, who's now the current sheriff, didn't take into account that conversion. And so when he was testifying to the times that these searches were performed, it was incorrect. And that is definitely something that the original trial attorney should have noted and made the jurors aware of, because specifically, if he testified that the data showed that the time of the searches was at a specific time, right? And that nobody else was home at that time, then the only person who could have used that iPad to do those searches was Todd Mullis, but he didn't take into account that you have to subtract. Then the data was interpreted and then relayed to the jurors incorrectly by the trial witness, which is the lead investigator of the which was the lead investigator. So that's a problem, so that's something that should have absolutely been addressed. And if the jurors were given testimony that it could only have been Todd Mullis who performed specific searches, and this witness had been, or a witness like him had been introduced to the jurors, and they heard, no, it was actually this time, it might have been, their outcome might have been different. We don't know. So, yeah. Thank you, Call Me Sadie, for gifting a membership. I appreciate that, babe. Thank you for supporting me, and the channel. I appreciate that so much. So yeah, that's why this is important. Now, I don't recall the Mullis family's converter box being in the original trial. Doesn't mean it wasn't. It just means I don't recall that testimony. But here we go. Let's hear what was on their box.
I extracted specifically some log files from that device to do analysis on.
Based on your extraction, could you determine what programs were watched and stored on the system?
There are 2 log files specifically that will help an analyst understand both the listings that were available to be watched on the device and also the shows or movies that were recorded and or watched by the end users.
Can you give me some examples?
Yeah, there were a number of Arnold Schwarzenegger titles that were viewed, recorded, and watched by the end users, and a number of History Channel shows to include Ancient Aliens, some presidential history documentaries, and a number of military-style historical documentaries.
So Clicker says it was not. This is new. So thank you for that, Clicker. I just could not remember off the top of my head. I mean, it's been a long time since I covered this trial, and so I probably have forgotten way more than I even ever knew, honestly. All right, here we go. Thank you. Call me Sadie. Says your commentary is priceless to me. Thank you so much.
Counsel, would you like to narrow your question?
Yes, Your Honor. Was there evidence of Sniper Into the Kill Zone show from the Discovery Channel on the DVR system?
Objection leading.
Sustained.
Well, hey, Margie. Good morning, sleepyhead. I'm glad you found us after your nap. You haven't actually missed much. We're just now getting into the real testimony about what he actually found. Now, he's testifying currently about their, I think he said DirecTV, their converter box. So it has their DVR and all that stuff on it. So that's what he's testifying to currently. All right, here we go.
Can you give an example of a Discovery Channel show that you saw on the DVR system?
Objection, relevance, and foundation.
Overruled.
I believe that there were a couple of log files extracted from the device that would represent the shows that were watched and recorded on the device. And if I could reference those log files, I would be able to better assist you in knowing all of those shows.
I would like to show the witness what has been previously marked as Exhibit 369. Can you tell me what this is?
This is a catalog.back file from the satellite set-top box, which is a file that could be used to determine what shows the user watched, recorded, or viewed on the device. It is a list of those shows and programming.
And can you go to page 15, please? And can you tell me what this is?
The daily schedule log is a log file that represents the guide. When you hit the guide button on the remote, this would show you the shows that are available to be watched or recorded on the device.
And how is it that you recognize these files?
They're documented on the Dish Network website as to gaining an understanding of what those files represent.
I'm sorry. I stand corrected. It was Dish, not DirecTV. My bad. Carry on.
Is this an accurate representation of the information you extracted from the Dish DVR device?
It is.
And just for the record, to be clear, this would be a portion of the extraction you did on the DVR system?
Yes, it is very specifically 2 files contained within the hard drive of that device.
Just pausing briefly because something occurred to me. I remember the old Dish TV commercials for their DVR. They called it the HOPPA, HOPPER, but I remember those commercials. The HOPPA. It was funny. All right, that's all. Here we go.
So if there is a show or something listed on the log file, what does that represent? What does that tell us?
It was a show that was available to be viewed on the device as far as programming that was available at that time. And a good way to correlate it would be to compare it to another document that would be representative of the shows available to be watched, such as a TV guide or a newspaper listing of TV shows available.
And for the, I would like to request to admit Exhibit 369 into evidence.
Any objection?
Yes, Your Honor. I'm going to
So many objections. Here we go.
The witness has already testified that this is only a portion of the extraction. Additionally, this file is comprised of, I'll say computer language instead of gobbledygook. So I don't see the relevance or how this will aid court.
Your Honor, may I be heard?
You may.
Your Honor, the state has the underlying data for this extraction. This is just a portion of the extraction is quite large, and it goes to weight and not admissibility. This will go into explaining later on the digital, correlating with the digital evidence that was presented at Mr. Mullis' criminal trial.
Do I understand correctly that this is just a listing of shows that were available through Dish to be watched? I mean, not necessarily shows that were watched, correct?
There's two files here, and one of them is, as you say, it's a list of files that could be watched. The first portion of this report were the shows that were actually watched or recorded by the device.
And how do I tell that by looking at this exhibit?
So at the top of the page of this particular exhibit that we have open, where it says daily log, that is the file, the shows that could be watched, like the guide part of it. The first part of this file, which was the .back file, which comprises of pages 1 through the catalog.back up at the top right there that you see indicates the shows that were recorded or watched, and that comprises of pages 1 through
Your Honor, while he's looking, I'm going to add an objection on calls for speculation.
Here we go.
I don't see anything in this that indicates when or if these were actually watched.
Well, I mean, that's my next question, is the date. I don't remember that there was a specific date provided.
There's the end of the back file right there. So everything preceding that daily log file portion of this report were the shows that were watched or recorded. To correlate the date of the actual viewing of those shows, the TV guide listing for the time period of these shows in question would represent those timestamps.
I need a spreadsheet and I need to see what we're looking at. Come on, what's the deal?
Okay, well, the next problem we have is I'm looking at what is page 14 of this exhibit of the document that was uploaded, which does not appear to be the same page 14 of what I'm seeing maybe on the screen. So let's go ahead and take our morning break at this time and see. Thank you. Please be seated. Okay, just for us, on in the interest of brevity, because this is a lot of testimony, I went ahead and sped it up to 1.5. If it is too fast for you, guys in the chat listening, let me know, okay? And I'll slow it back down again. Go ahead and have a seat. Mr. Castle, I'll just remind you that you remain under oath. And Ms. Steedson, I think we'll pick up maybe with some foundation questions with regard to Exhibit 369.
Yes, thank you.
All right, you may proceed when you're ready.
Mr. Castle, in pages 1 through 14 of this document, you mentioned that this is the catalog.back files. Can you, are these the, is it your testimony today that these are the shows that were recorded and watched on the DVR system?
Objection, leading.
Overruled.
This file represents content that was viewed, recorded, or watched even in part by the users on this device.
Are you able to determine the timing that these shows were recorded and or watched?
With this document alone, and no.
How can you determine that?
Using correlation and aligning it with the TV guide schedule at the time.
And is this something that you typically do in your line of work?
Yes, using multiple data sources to gain an understanding of context and timeframes is important to understanding the scope of the whole thing. Yes.
Mr. Castle, do you know what dates your extraction data covered?
Based on this document, it does not show the specific date range.
Okay, so Henry says bench trial, interesting idea. I think if I were innocent and wrongly accused, I would go for bench over jury. I wonder what the criteria are for allowing the possibility of bench. As Neat Noodle answered, every defendant in a criminal trial has the option, I think, also in a civil trial. You can have the judge preside over the trial, which would be called a bench trial, or you can opt for a jury trial. Okay. And in this situation, because this is a post conviction relief where the defendant is actually referred to as the applicant in these types of proceedings, he's already had an original trial, and he's raised a ineffective, among other things, but specifically in this bench hearing, he's raised the issue of ineffective assistance of counsel. And so this judge is hearing that right now. So in post-conviction relief, the judge is who is the fact finder in those hearings always. Now, it is my opinion that for certain trials, highly emotionally driven trials, for example, we watched a trial on this channel about Henry Dinkins, who who stood accused of murdering his former stepdaughter, who was 10, I think, at the time. Because of the type of charge, it would have been a highly, and it was, even though it was a bench trial, it was a highly emotionally charged trial. There was highly emotionally charging evidence, it's illicit. So you would, in that situation, I think a defendant would want a bench trial. Hold on a second. I have to cough, and I don't want to cough in you guys' ear. Also, if you're in a criminal trial, right? If you're the defendant in a criminal trial and the evidence is very nuanced, complicated, if I were a criminal defendant, I would want a bench trial. I support our system of the jury. I support our justice system, the jury system. I do support that. But I do think that when it comes to jurors, there are things that can be problematic. For example, the jury instructions. Jury instructions are like a mix of legalese and regular everyday language, and understanding what a juror has to find in order to substantiate a guilty verdict on a specific charge. Sometimes, depending on the case, obviously, can be quite complex and kind of nuanced. And some jurors have problems understanding the language that's in jury instructions. That's an issue. Also, I think that because jurors are regular everyday people in the community who are selected, typically, obviously, that's how they pick the jury members, but they have jobs that have nothing to do with the justice system in any capacity. And so it's like a double-edged sword when it comes to the weight of evidence. For example, let's take this trial, the original trial, right? I think if I were sitting on this trial, I would take all of the testimony given into consideration. However, I would give different weight to different testimony. While I do think it's important for witnesses, not expert witnesses, lay witnesses, if you will, their testimony about what they may have seen, what they may have heard, or a backstory about how the defendant and the victim might be known, or whatever the case may be in that situation. It's good information, right? However, there are times when I would probably give less weight to that testimony versus the testimony from, say, the person who performed the autopsy, right? To me, it's good backstory information, but I think that evidence of what actually happened, to me, or what the results of an autopsy were, carry more weight in that regard when it goes to finding, guilty or not guilty. So I just think I have to say this is funny. Greg says, listen to them trying to sound big and scientific talking about a common DVR settings, right? Like, why are they why are they complicating this? We all at this point know how to work a DVR. It ain't that deep. I don't understand why we're using big ass fancy words, but whatever. Let's let them do it. But you did, Neat. You explained it well. Let's see what you said. Neat says, it would have been the appeals court that initially looked at the claims and agreed that the appellate attorney's arguments had enough merit to send it back to the judge for a trial. Yeah, you explained it correctly. So it would have, when Mullis, when his appellate attorneys first raised this issue, they would have filed, right? And it would have gone through the appeals process. And at a certain point in that appeals process, a judge would have looked at it and said, yeah, I think we need to have a hearing on this, which is where we are today, which was actually like 2 weeks ago. So, yeah. All right, let's keep going.
I happen to know from the TV Guide stuff what it may have covered, but this document does not show that.
When you extracted from this DVR, did you extract all the data from the DVR system?
Yes, it was a comprehensive collection of all the data represented on the hard drive, and these log files represent that.
Do you recall what date you collected this data?
Without referencing the forensic image I created of the hard drive, the forensic image of the hard drive I created, I would have a hard time recalling that.
What year would you have done this?
2022.
And so the data included on the DVR system would be from whenever the service plan would have started to when you extracted the data?
I do not know of what the log file's start date is. I just know when I collected the data.
I mean, I don't want to be this person, but I have to be this person. The applicant's table over there, i.e. the defense table, this is your witness. Perhaps, I don't know, show him a page from his report that might refresh his recollection so he can know what the dates are. And also, yes, most people know how to work a DVR, right? But if you're going to download a DVR, it would be helpful to create some type of workflow product that is easily discernible to the fact finder, be that a judge or a jury. Just some suggestions. Follow me for more tips and life advice. Here we go.
I don't know when the family chose to decommission or stop using this particular set-top box.
Hey, Allie. Good morning, babe.
We'll come back to this issue.
Also, I'm a bit confused.
Did
Hold
the state do
on.
an extraction on the dish DVR?
Excuse me. I'm a bit confused about why there's so much conferring back and forth at the applicant/defense table. This is your witness. I don't understand this.
DVR system?
I don't believe so. I believe they only received what the forensic image of the hard drive contained and data from me and reciprocal discovery.
One more, Your Honor.
Oh, for Pete's sake. Like, this is, I understand. I mean, they had a whole break and they knew that they were going to be expected to lay foundation. So what's the hubbub, bub?
Mr. Castle, during your analysis of the dish DVR system, did you look for History Channel TV guides?
Your Honor, I'm going to object at this time under as relevance in 403 that this is a waste of time because, for example, this document from the DVR says the Andy Griffith Show. If this witness is truly going to say that he...
This is a waste of time. Okay, I got to take a minute just really quickly here because I keep pausing. It's going to take us 7 years to get through this testimony, even though I have it sped completely up. But here's the deal. What I appreciate about the state's attorneys over here who are speaking is they don't mince words. And I find that funny because I don't actually think, I know that if this were a trial with a jury, right, they wouldn't use a waste of time, but they do in this case. And it's a formal hearing and it's important, but it's a little bit more relaxed because it's a bench trial and it's for post-conviction relief. It's not a criminal bench trial. And so I just find the fact that this whole side of the table over here just tells it how they feel it. And it makes me laugh. And I quite frankly enjoy it. All right, here we go.
Can identify which specific iteration of the Andy Griffith Show was watched or recorded or whatever show it is, that there was no reruns at any point other than what could conveniently line up with their theory of the case. This is speculative and this isn't worth the court's time in the state's opinion.
Well, counsel, did you wish to respond?
Yes, Your Honor. This is providing contextual information about what was going on in the Mullis home and also provides corroborating evidence regarding the Google searches that were presented at Mr. Mullis's trial. The state at trial presented these searches without any corroborating forensic digital evidence, and we are now able to do so.
Okay, to be fair, all right, there's been many times if my phone was downloaded, right, and they were looking at my searches, downloading my Fire Stick would be very helpful because there are times when I'm watching a show or a movie and I see an actor that I recognize, but I'm not sure where I recognize them from. I will, like a whole nerd, Google first the show that I'm watching, look for the character's name, the corresponding actor. Then I will click that actor's name and I will go through their whole IMDb. So, I mean, that does happen. Have I ever Googled some of the things that Todd has Googled, or that I shouldn't say Todd Googled? My Google searches with respect to shows don't look like some of these Google searches that were recovered off of the iPad. That is true. However, I don't watch the same type of shows that the Mullis family was watching. So perhaps if I did watch different shows, my Google searches would obviously be different. So, but can we speed it up? Defense applicant, can we have more of a question answer in rapid succession than a question, an answer, some talking over at the table? Like, can we get this streamlined a little bit, please?
Which relates to the ineffective assistance of counsel claims in this instant PCR.
I mean, as it stands, I don't have any information about the dates that would correlate to this information, so I'm having a really hard time connecting it to anything that could be considered relevant, at least without that information.
So, Sarah, oh my gosh, I totally meant to email you back. I'm so sorry, babe. I'll email you right after this. So Sarah says, at my jury trial, which she was a juror on, she wasn't on trial, just for clarity, defense and state got into it, and defense said this is getting silly, and then louder, nothing further. So I wouldn't be so sure they won't say things like that. I mean, they do say it happens, but usually they try not to let it happen. Do you know what I mean? And I feel like some of the petty language that the state has used, like gobbledygook, which personally I like. I don't think they would. I don't know. I just feel like the specific attorneys sitting at the state's table probably wouldn't do that at an actual retrial, but maybe they would. And if they do, I'll be here for it. All right, here we go.
So
also, I have to agree with the judge here. It needs to be much more. There needs to be a clear parallel, right, between what was actually watched. Let's start here. I would like it if it was, here's what they recorded on their DVR. Here's when they watched it. Here is the corresponding Google search. This is just too all over the place and a little ambiguous.
You know, again, if there's some further foundation that you can lay to tie that in some way, you certainly may do so.
One moment, Your Honor.
I mean, I understand why they want to get this in. I just wish that they, I wish that they would have done it in a more streamlined fashion. And clearly Todd does as
Your
well.
Honor, I will just move on for the moment.
Go ahead.
You can. Mr. Castle, based on your knowledge and experience, have you done examination in internet browser-based searches?
Yes.
What is the difference between a browser and a search engine?
A search engine is a program that is built by a content provider that will index and catalog web pages and the data contained on those web pages on the internet. A web browser is a program that is used to view the web pages on the internet specifically.
What would be an example of a search engine?
Google, Yahoo, Bing, web crawler, Excite are all web-based search engines.
What is the example of a browser?
A browser would be Google Chromium, Mozilla Firefox, Apple's Safari, or formerly Microsoft's Internet Explorer.
Let's talk specifically about Google. If you were signed into a Google account on a certain browser, does Google track your searches?
It is an option that the user can elect for Google to maintain a comprehensive list of the searches that were conducted in that browser session, and is not necessarily device specific.
And is this typical?
It is.
Can you explain the difference between a device and an account?
A device is a physical piece of compute hardware, such as a tablet or phone or laptop. An account would be the user profile of the individual signing into that device. There can be multiple devices. There can be multiple accounts tied to devices, and synchronization options chosen therein.
What happens if a Google account is logged in on multiple devices?
There will be evidence artifacts of searches across multiple devices represented in the data that Google catalogs, and in the subpoena reply from Google, it will reflect multiple searches conducted on those devices.
Could two people be searching on two different devices on the same Google account?
Yes.
Would this all be saved in the search history for the account?
Yes.
So Google search history is not device specific?
It can be device specific, but it also can be tied to the user account tied to the device as well. So.
And the objection's overruled. The answer will remain on the record.
So if I understand you correctly, just because it is on a Google search history doesn't mean a certain device searched it?
I'm asking you to be a little bit more specific.
So if I had this phone signed into my Google account, and Tara's iPad was signed into my Google account, and I searched on my phone, could the search appear on Tara's iPad?
Yes, based on user synchronization options, absolutely.
Can you explain the difference between a search and web history?
Just so you know that I am super duper lazy. And so a lot of times I will start a search on my phone, and then I have the option to send that search or the search results over to the desktop. I do that quite frequently. Say I need to look something up and I think about it while I'm outside having a smoke. Usually I have my phone with me, right? So I send it to my tablet or to my desktop. I hope, knock on wood, that I never need to be searched because there's going to be oodles of data for them to go through and try to correspond and correlate because I do that quite frequently. Let's keep going.
A search is an end user typing a query of word or phrase into the search engine, asking for results. A web history artifact or evidence would be the visiting of a web page or the following of a link from those search results.
Did you review Mr. Hemisath's testimony regarding Todd Mullis' 76 Google account?
I did.
Do you recall him saying that there was no evidence of Todd Mullis' 76 Google account on Mrs. Mullis' cell phone?
I recall that.
Was that accurate?
No.
Were there indicators that Todd Mullis' 76 Google account was tied to or connected to multiple devices?
Yes.
And which devices were those?
The iPad and Ms. Mullis' phone.
Did you review the Google searches obtained from Todd Mullis' 76 Google account that were obtained by the state in the underlying trial?
I did.
Mr. Castle, are you aware that Todd's children took a hunter safety course?
I am.
Objection, foundation.
Overruled. The answer will remain in the record.
I would like to show the witness what has been previously marked as Exhibit 306. And
Okay,
just for ease of reference, this has been
hold on a minute. I want to call me Sadie says, I hope I never get arrested because my Google searches would convict me. I don't think that my Google searches necessarily would quote unquote convict me, but I'm telling you, they would definitely earn a strong side eye. People would be wondering, like, why is she searching for, who's the last, I searched for somebody. I was watching Long Legs, or no, it wasn't even Long Legs. It was some other movie that I was watching recently, and the voice was super familiar to me, but I couldn't place it. So anyway, long story short, it winds up after going down a rabbit hole that the actor who was shown on screen, the reason his voice was familiar to me is because he was the voice of Creature in the Harry Potter films, right? But that was also mixed in with another search about how often other people's DNA is found under fingernails. For like, that's not the actual search I did, but it was like, how often is DNA belonging to other people found under a person's fingernails? And I did that because I was looking, the Idaho 4 stuff had come out, and I was trying to understand how that related to what had come out, which I actually found some really interesting stuff on that. So, but anyway, like, it's all mixed in there. So I'm sure I would get a probably well-deserved side eye. And Lord forbid they put me on the stand to explain it, because we'd be here for 7 years. Let's keep going.
made into a demonstrative exhibit M that has been provided to the state. This is, sorry. Mr. Castle, what is this?
It is a media document containing information regarding hunter safety.
Matt, are you asking if you can't? No. Maybe I'm missing something because no, this judge is definitely not the same judge as the Gannon Stout case. This is in Iowa. So there must be another comment that I missed. All right, here we go.
Did you review this over the course of your investigation into the Google searches?
It was one of the documents used as correlation to understand the searches that were conducted across multiple devices.
And are you familiar with this handbook and how it relates to the Google searches found on Todd Mullis' 76 Google account?
I'm going to object that on relevance, foundation, speculation. There's been no foundation that this document specifically was used or read by anyone or when, and where this line of questioning is going is the exact same as the DVR.
Would you like to respond, counsel?
Yes, Your Honor. This document will show that the Google searches are exactly verbatim for what this hunter safety course purports in their with the internet searches. And the trial counsel could have found this document and should have known that Todd's children had taken the hunter safety course and would have had access to this information.
Okay, and maybe that's true, but again, as far as foundation for how this witness would know how anything about this would correlate with what he did is maybe unclear at this point. So if you'd like to lay some additional foundation, you can certainly do that.
Mr. Castle, did you review Exhibit 306?
This document?
This document, yes.
I did. During the course of the investigation into the Google searches that were conducted across multiple devices, I noted a pattern that was curious in regards to they all seem to be related to outdoor shooting activities and firearm safety. Upon further research, I discovered that there was the pattern lined up with maybe an open book test or some type of exam as regards to the hunter safety course.
And did you review the trial testimony of Mr. Hemisap regarding this series of searches?
There seemed to be some question as to the specificity of the searches being of a violent nature, and to gain a better understanding of the pattern there, I wanted to see what came about. It revealed itself to be a series of searches regarding firearm safety and very specifically...
I'm going to object, Your Honor. This is speculation and foundation once again. This witness has not established that any particular person in the Mullis family or anywhere else has actually reviewed this document, and it's speculative.
Well, I guess I'm not sure how the witness got this information or what his investigation revealed or where he got this particular guide from. The witness can continue his answer.
Your Honor, in the course of the investigation, when I noticed that the searches conducted on multiple devices, the laptop, phone, and tablet, reflected a pattern of firearm safety specifically and hunting, there was a timeline that emerged that demonstrated an evening of study in regards to firearm safety and hunter safety.
Your Honor, I would like to also note for the record that the state previously indicated that they would not be objecting to foundation or authentication or identification of this particular document.
And while that is true in our preliminary objections, the court did subsequently grant good cause to the state to be excused from the foundational requirements pre-trial. And however that may be, we don't object to the foundation in that we don't need someone to come in and authenticate this document comes from whatever magazine it's from. That doesn't mean this witness has not laid the foundation for how he is aware of this exhibit or how it pertains to this case.
Agreed.
A few follow-up questions.
You certainly may. I think he had finished his previous answer.
Thank you, Your Honor. Is this document the official study guide for the Iowa DNR hunter safety course?
Objection, foundation, leading, speculation.
Right. It's sustained.
I think it's a fine line here in this particular.
Enter Exhibit 306 into evidence.
Hold on. I think it's a fine line in this particular situation between being thorough and overwhelming the judge. And I think that in some of the testimony and evidence, the applicant, i.e. the defense, while I appreciate the thoroughness of the job that they're doing, I think it's a little overwhelming to the judge. And I think I don't misunderstand what I'm trying to say here. I do think that it's important to be thorough, and because I believe in our justice system, it's people who are actually innocent. They were actually did not commit this crime for which they've been charged and then subsequently convicted of. That's very different than some loophole where there was some trial error and they should get a new trial. That's not the same as an actual innocence claim. But thinking about somebody who is actually innocent being convicted and sentenced to jail for life does keep me up at night. So I appreciate the job that this defense is doing. I just think that it should be, for purposes of this bench trial, what they're trying to accomplish. Like I said 11 billion times before, I should probably take my own advice. I wish it would be more streamlined and quicker.
Mr. Bakke?
Again, we do not object to the foundation that this is, in fact, a magazine. I would object on relevance to this case, as no relevance has been laid.
And again, on the relevance point, I still don't have any information necessarily about specific timeframes, where this came from. I agree. I'm not seeing the relevance yet. It just hasn't been demonstrated by the evidence. If you'd like to continue to lay some foundation, you certainly can. It will not be admitted at this time.
Just one moment, Your Honor.
Oh my gosh, Sarah says my searches would look terrible until you realize I'm researching succinylcholine while Forensic Files episodes about said. Yeah, me too. I know exactly what episode that is. It's about the woman who was purported by her husband to have fallen from a horse.
Your Honor,
I remember that
the
episode.
court may not have reviewed this yet, and I completely understand there's a lot of documents, but there is in the record for this PCR case, in the deposition of TPEM, it does indicate that hunter safety courses were taken and completed. It includes certificates that proves that TPEM and Tristan took these courses and were certified. Additionally, this is the hunter safety course. It is not a magazine. It is this the study guide for this hunter safety course that the DNR utilizes. And TPEM's deposition has been admitted into evidence.
And I understand that, and I have reviewed that, and I am aware of that, and I don't think that that's
not the issue. It's how did this specific witness become aware and correlate the searches with this hunter's class? And I do think that it needs to become more clear.
the basis of Mr. Bakke's objection. I think his point is that that information hasn't been tied to this witness. I mean, is that fair, Mr. Bakke?
Yes, Your Honor.
Okay.
We certainly do not dispute that some hunter safety something was completed at some point, but it's the connection between the two.
Your Honor, may I be heard briefly?
Sure.
Mr. Hemstead's testimony at
I'm just going to say this for this. I like this attorney and I think she's doing an excellent job. Okay. But there's a song for ministry, connect the goddamn dots. That's what they're asking for. Please just connect the dots, babe. You're doing great. Don't be nervous. You're clearly educated and extremely smart, but you got to connect the dots.
trial has specific searches, a series of searches that indicate this, that are related to the hunter safety course, and they have a specific date tied to them as they are from the Google subpoena, and so they have the actual date of the search. The certificates that also are in evidence that of the hunter safety course shows just a little bit later. There's also additional Google searches that correspond with the field day searches, which includes the follow-up to the online test that TPEM was taking on the day of the Google searches, and this is provided in her testimony. And Mr. Castle had access to the Google searches. He had access to Mr. Hemstead's testimony regarding the Google searches and his own experience on using correlative data to understand evidence and what trial counsel should have done at trial, with Todd indicating that his children had taken these.
So I think Mr. Bakke's point, Ms. Steenson, is essentially that all of the factual assertions that you just made in your argument just need to be asked in the form of a question to the witness so that we can get that into the record. If I'm understanding his objection correctly?
Yes, Your Honor.
Okay.
And I would additionally note, it just was pointed out to me that this document is also copyrighted in 2022, which, if I understand correctly, is after this trial.
I mean, obviously, yes, Mr. State Attorney Man Guy, yes. 2022 comes after the original trial, which was in 2019, and also after when these searches would have been done, which would have been in 2018. Yes, 2022 comes after both 2018 and 2019. Fantastic point, I guess. Thanks.
So are you objecting to?
Yeah, what are you
Just
objecting
plays into the
to?
relevance objection, Your Honor.
Well, and so maybe this document being used as a demonstrative rather than an exhibit, and I guess I'm a little bit confused about how you're intending it to be used. You referred to it both as Exhibit 306 and also demonstrative M. So we'll maybe need to clarify that at some point too, but I guess maybe you want to address that as well, Ms. Steenson. So,
Just to clarify the record for the point that you had just asked, this is, the hunter safety course is what has been previously marked as Exhibit 306. The demonstrative has certain pages from the guide included with the Google searches just for ease of reference, so it is not, we're not jumping from exhibit to exhibit, so it is just to make that exam hopefully a little bit more streamlined, Your Honor.
okay, I understand. Those are two different things.
Yes, Your Honor.
Okay. All right. Back then to the issue maybe of some additional foundation for this exhibit. Did you wish to follow up on that?
Yes, I would, Your Honor.
Okay, go ahead.
Mr. Castle, did you review Mr. Hemes's testimony regarding the Google searches on Todd Mullis 76 Google account?
Not only did I review his testimony and transcript, but I also had opportunity to review the subpoena reply from Google regarding the searches conducted across multiple devices.
Did you review, based on Mr. Hemes's testimony, the searches that were testified to in August of 2018?
I did.
And did those searches stand out to you?
Yes. The subject matter contained within those searches was interesting and curious in the means that it was discussing firearm safety, and that some of the searches conducted also referenced the hunter safety guide, specifically the taking of an online test.
Have you personally taken a hunter safety course?
Objection, relevance.
Overruled.
In the state of Nebraska, I did complete and take the hunter safety guide, the coursework, took the test so I could become a hunter in my state. That's what gave me the understanding that some of these searches were relevant to that particular topic.
Your Honor, I'm going to lay an additional objection at this time that I'm unclear of what the scope of this expert is at this point. I believe he testified that he's a digital forensic expert, a network security consultant, and I believe he was only certified for those purposes, and now it appears that he's trying to be certified as a hunter safety expert and some sort of sociologist on what the inner workings of the Mullis family, what they're watching on TV, what they're Googling, and why, and it far exceeds the scope of this expert's background in digital forensics.
Your Honor, may I be heard for you?
You may.
Mr. Castle has demonstrated that in addition to being a digital forensic examiner with extracting data and analyzing the evidence, he also uses other evidence to examine such evidence for interpretation and investigation, and in showing how correlates and causes how you can interpret the data. The data used at trial was solely these searches, and it was very misleading without this other information surrounding these searches, and that is what Mr. Castle does as his occupation, and he is very well qualified to provide information about what these searches mean with the corroborating evidence.
And briefly, the state likewise believes this testimony is very misleading in that this digital forensic expert is attempting to connect dots far beyond the scope of the foundation that has been laid and beyond the scope of his expertise.
Certainly the court does not consider Mr. Castle to be an expert in hunter safety. Even if he was, that is not an issue that is relevant in any way to this trial. I think we are getting off track and making this issue way more complicated than it needs to be. Certainly the witness can testify about the commonly accepted practices within his area of expertise used to verify data that he extracts from devices or to interpret the data that he extracts from devices. That's where our focus needs to be, I think. And the court's not going to consider him an expert for anything beyond the areas that he is, in fact, an expert. So, Ms. Steenson, if you would like to ask another question, you may go ahead and do so.
Yes, Your Honor. I would like to show the witness what has been previously admitted as Exhibit 270, and I would like to show page 3. Do you see this exhibit?
I'm just waiting for the signal to come up on screen. It's still not being displayed yet.
Okay.
I'm not sure. Did you switch devices or?
Erica, can you turn on the TV? It's been admitted. Well, just so we can see what the connectivity issue is potentially.
And Your Honor, we just discussed, since this is admitted, we're fine with this being to help us all see.
Okay, 270, sure.
I also have a paper copy I can just bring up to the witness at the floor.
That's fine if you'd like, sure. I'm not sure why it's not popping up on the screen. Did you switch devices or?
Yeah.
Okay.
Mr. Castle, can you flip to page 3 of this exhibit?
Okay.
Do you see a series of searches that are dated August 7th of 2018 UTC?
At the bottom of the page, yes.
And then this continues up to searches that begin on August 9th, 2018 UTC?
Yes.
And just for the clarity of the record, do the searches go sequentially from the bottom of the page to the top of the page?
Yes.
The search dated August 9th of 2018 at 17:38 UTC. Can you tell me what that search is?
What fraction of firearm incidents occur in the home?
And based on your knowledge and understanding of UTC time, and your knowledge of, what time would this search actually have been conducted in Iowa time?
So it's the time denoted in UTC is in military time or 24-hour time period. So it's not denoted in 12-hour time period. So it's 17, 38, 25 seconds. So if you subtract at this time, in August would have been daylight savings time, so 5-hour offset. So it would have been 12, 38, 25 seconds. Would have been the time UTC according to that entry in this document.
And what would that be in Iowa time?
Sorry, in 12-hour, I just gave it to you. The minus 5 hours is 12, 38, 25.
Thank you.
And that's UTC time codes, yeah. The adjusted for 12-hour period would have been, it doesn't, sorry, 1,700 hours minus 5, 12 hours, 38 Central Standard Time, daylight savings time adjusted.
Is there a search just a few moments later?
Which one specifically are you asking for?
The one just right above.
Search for examples of elbow carry of a firearm.
And what is the next search that occurs?
The search for checking for an obstruction in your firearm.
And what time is that search done?
1743.
And now I believe that the exhibit is on the screen. Do these searches continue through August 9th, 2018 at 20:21:42 UTC?
They do.
So Patricia says, I've got a strong feeling that the judge is not going to rule in favor of a new trial. I don't have a real sense of how this judge is going to end up ruling, because while she does appear at times to be a little annoyed, frustrated perhaps, I think that's just in that moment. But I do think that the biomedical test witness, Dr. Nye, the forensic pathologist, Dr. Hammers, and also the digital forensic testimony, I think that is important. And I do think that while a client can request a specific defense or want a defense, it's ultimately the job of the defense attorney to be the one that decides the type of defense that they will or will not put on. Okay, because it's real, they're not required to actually put on a defense. But the fact that in opening statements, while opening statements are not considered evidence and the jury is instructed that they're not evidence, it's problematic when you have your attorney conceding that a murder took place. That's problematic. So I need to keep watching and see if I can get a better sense of what this judge is going to do, or what I think she should do, like what my opinion is. I do think that there's definitely, just in the testimony that we've heard thus far, mainly from the experts. And how could I have forgotten? Probably one of the most important witnesses, that what the first responder that arrived on scene and testified to Todd's demeanor and what she observed in the with respect to Amy Mullis, the state, her condition, etc. That I forgot about that. So that's like the sixth. Then there have been 6 witnesses. So or 7. I can't. That was important testimony, and that is testimony that would have, I think the jury should have heard that. And it's really difficult to say, well, if a jury had heard from her, perhaps they would have thought differently, because I'm sure that the jury would have found her credible. But I think that I think the most compelling evidence that a jury may or may not have ended up convicting Todd Mullis had they heard this specific testimony, I think actually the more compelling case for that comes from the expert witnesses.
And as you can see from the not only just searched but visited web pages, there are references, multiple references to different states' hunter safety guides.
Oh, and before I forget, I find it a kind of I kind of wonder about this test that was being taken online. I don't think that it's supposed to be an open book test. I would think that if you are taking a course in hunting safety, the idea would be that you understand hunter safety and can be asked questions about it. It's a little disconcerting if it were an open book test, because that means that you may not actually know and understand all the things that you need to be a safe hunter. I'm not sure. I don't know how it's a little disconcerting to me if that is an open book test. All right, here we go.
What indicated specifically in these searches to you that they were connected?
The time frame in which the sites were searched and the subject matter visited subsequently. So there would be a search for a topic surrounding firearms or hunter safety, and then there would be a web page visited pertaining specifically to hunter's education.
MK Lynn, what up?
Can you look at
Good to see you, bud.
Google history, same page, August 9th, 2018 at 174416 UTC. Can you tell me what that website that was visited is?
You said 17 what?
174416 UTC.
Visited Quizlet.com, hunter safety quiz, flashcards.
And the visited site right above that, can you tell me what that is?
Huntersed.com Washington/study guide, loading and unloading steps of a firearm.
And a few searches up at 174852, can you tell me what that Google history is?
I'm going to object that this exhibit speaks for itself. This was admitted, I believe, as Exhibit 105A at the underlying trial, according to the sticker on the front page. The court can certainly read every search and visited site if it so chooses. The jury would have had the Google searches to review for themselves. I just believe under 403 this is a waste of time in the state's opinion.
Your Honor, may be heard briefly.
Yep. I'll allow the applicant to make whatever record they think is necessary. If you want to continue, Ms. Steenson, you may, so the objection is overruled.
And do these searches based on and this Google history based on your knowledge, experience?
Okay, but to the states, so the state's like, oh, this was in the original trial, yada, 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 whatever. Right. It was in these searches were, that's not the point. The point is, during the original trial, was this avenue explored by the defense? That's what's at that's what the crux of all of this is. Not, we all know that it was available. This isn't quote unquote, this portion isn't quote unquote new, right? But was this an avenue that was pursued by defense because it's an ineffective assistance of counsel appeal?
Experience and education indicate that they're for a hunter safety course, people searching for answers to potential questions.
Objections beyond the expert's scope. The exhibit speaks for itself.
Overruled.
Yes. The searches and subsequent visits to websites would reflect, as far as pertains to digital forensics artifacts and evidence, the viewing and searching for subject matter pertaining to hunter's education and a test therein.
Okay, we got it. So basically what he's testifying to is that all the firearms and hunting stuff, Google searches, relates to that online course. Easy peasy lemon squeezy. All right, let's keep going. And now, ask your question.
Do you find this correlative nature of the searches, starting with the first search we mentioned on August 9th, 2018 at 1738 UTC, what fraction of firearm incidents occurred in the home, that it's related to the search of elbow carry of firearm?
Before he answers that, MK says pizza rolls for everyone. Will they be served with ranch? Also, are they pepperoni pizza rolls, combination pizza rolls, sausage? Come on, I need to know more. Although I do like all pizza rolls. It doesn't really matter. It's just for my own curiosity. Here we go.
Overruled.
The searches as reflected in this document show a pattern of a given subject surrounding firearm safety, then a visit to a web page, very specifically having to do with hunter's education and firearm safety.
Hunting animals, obviously not hunting humans. Get it. I got it. We got this.
Can you look at the search dated and timestamps August 9th, 2018, 1751-53 UTC, and can you tell me what that one says?
It was a search before action to take if one falls into cold water.
I need to pause briefly for a quick sidebar. MK says the 4 cheese ones, but I hook them up with all kinds of extra stuff. Now, in between eating, would you mind giving me a fuller explanation and description? Because pizza rolls themselves are delicious, and if they can be improved upon and add to their deliciousness, I need to know all the things. Please and thank you in advance. Let's continue.
And can you tell me what the next search history is for that search?
Very specifically, you referenced the search of what action to take when one falls into cold water. There was a visited website directly after that search on boat education, what to do in falling into cold water treatments as a result of that search.
So your expert opinion, is it your expert opinion that the searches from August 9th, 1738, 25 UTC through August 9th, 2018, 20, 21, 49 are all searches that relate to Hunter safety course.
Objection, the foundation hasn't been laid for how these all connect and relevance.
That's what she's asking.
Overruled.
Chronologically, in time, they show a pattern very plainly of a search for a topic, and the topic then visited of a web page that directly correlate to firearm safety, hunter's education, and survival of outdoors. The web history and searches reflect that pattern. The correlation of that data seems fairly straightforward with the evidence of these searches and web history visits.
I would like to talk about Mrs. Mullis' cell phone for a moment. Based on your review of digital forensic evidence, do you know that Mrs. Mullis created her Amy Mullis 5810 account on July 19th, 2018?
There appeared to be a new account created on Ms. Mullis' phone, as reflected by the web history, and as well as some unique dialer codes reflected in her call log.
And is it your understanding that she used this email address to solely communicate with Derry Frazier?
Objection, foundation, irrelevance, speculation.
I would like to show the witness what has been previously admitted as exhibit, I believe 308.
Okay. Did you wish to withdraw the question or respond to the objection first?
I would like to witness the foundation if that's
Okay, go ahead.
Can you pull up exhibit 308? And can you scroll to the last page? Does this exhibit show the communication between Amy Mullis and Jerry Frazier?
The document shows a number of email threads as communicated by the amylin5810@gmail.com and an email account of Jerry Frazier 70@gmail.com. 70@gmail.com. And again, as prosecution counsel mentioned, these items are
I
truncated.
don't believe this is responsive to a pending question.
Let's have a new question, please.
Yes, Your Honor. Based on your extraction and analysis of Mrs. Mullis' phone and her email records, did Mrs. Mullis email anyone else using the Amy Lynn 5810 Google account?
Objection, there's not foundation laid that this is every email ever sent. This is an extraction of a device, I believe, not an extraction of the Gmail account itself, unless I misunderstood.
I guess I understood it maybe the same way. Do you want to clarify that, please, counsel?
Yes, Your Honor. Mr. Counsel, did you analyze Mrs. Mullis' cell phone?
I did.
Did you analyze her email address, Amy Lynn 5810 Google account?
As the artifacts or evidence was represented on her phone, yes.
Did you receive a subpoena response from the state's discovery on the underlying criminal trial of the Amy Mullis email account?
I did.
Based on your analysis of all the evidence and all the data related to the Amy Lynn 5810 Gmail account and the phone records of Amy Mullis, were you able to determine that Amy Mullis only emailed Jerry Frazier through this email address?
I'm going to object on speculation, although I understand that that's all the data he saw. I think it's too far to say that conclusively is all the data that exists.
Your Honor, may I be heard briefly?
Objections overruled. The witness can answer if he is able.
Based on my recollection, yes, this Gmail account created by Ms. Mullis on her device was the primary modes of communication between herself and the account of Jerry Frazier 70@gmail.com.
Do you recall a search regarding checking the content of text messages on the phone?
I do recall that search.
I would like to publish what has been already admitted exhibit 270 on page 7, which is the Google searches.
You may. The witness has just asked for some water. Maybe if someone, counsel grab, would like to grab that. Thank you.
Thank you so much.
Oh boy, I'm gonna have to skip.
Able to see the exhibit?
I am now.
Okay. Are you able to see the exhibit?
I am now.
Okay, so for the
Just as a side note, I'd like to point out that I received an Instapot with all the accoutrements one year for Christmas. I love the Instapot. I love all the things that it can do. But because it requires a different lid for each different thing, there's like 2 different lids. It's a little bit hard to just pull out every single. It's also heavy every time you wanna do something in the air fryer, but my daughter has, like, one of those air fryers that's for the countertop. I am in love. Highly, highly 10 out of 10 would recommend. All right, here we go.
Record, this is Exhibit 270, page 5. Is there a search on July 21st, 2018 at 14339 UTC?
Yes, I see that entry. That entry reflects a search for checking content of text messages on a phone.
And was this search conducted in UTC time?
That is what the document reflects.
And what would that be in Iowa time?
Sorry. The 14339 is the one we wanted to, so it would be 8. 8 a.m., I would believe.
And this was on July, this would have been on July 20th, 2018 at 8:43 p.m.
Sorry. No, I believe it would be 8 a.m. If all this is in 24-hour time period stamps, then that would reflect a 1 p.m. UTC time code stamp, or minus 5 hours, 8:43 a.m. time period stamp. If these are all reflected in 24-hour time clock designation.
So this is 1:43 a.m. UTC, so minus 6 hours would be 8:43 p.m., is that right?
Yes, I apologize for that mistake. That would be correct.
And this would have been done on the preceding day of July 20th, 2018, instead of July 21st, 2018?
And to correct my mistake, the 24-hour time period designation would have been 1,300 hours for a 1 p.m. time frame, so I apologize for that mistake. Yes, that is correct.
Was there any information in the phone records you examined that corroborated this, correlated with this search?
I'm going to jump on foundation on that. This appears to be speculative.
I'm sorry. What appears to be speculative specifically?
I guess I'll withdraw the objection and see where it goes.
Okay. Do you remember the question, sir?
She was asking me if this search correlated with an evidence artifact on the phone records for this device as well.
And you may answer that question.
Yes, it did correlate to an interesting record on the as an entry on the phone record. Specifically, as a very short phone number that was an incoming artifact.
Just one moment, Your Honor. Mr. Counsel, did you review other Google searches connected to other Google accounts, such as Mullis RN Google account?
In my review of all this data, I had opportunity to review the subpoena returns for multiple Gmail accounts, and it was all taken into consideration in building my conclusions and understanding of these events, yes.
And were there similar searches on this mullisrn@gmail account to the search presented in Exhibit 270?
Yes.
I'm going to object. That's vague and overly broad. This is 270 is 12 pages of, I don't want to characterize a number on it, but it's a lot of searches.
Can you ask a more specific question, please, counsel?
Yes. Based on the search we just mentioned about checking the content of text messages on the phone, were there similar searches on the mullisrn Google account that you saw during your analysis and examination of the forensic digital evidence in this case?
As previously stated, there were multiple accounts tied to Ms. Mullis's phone. The mullisrn account and the Amy Mullis 5810 account being tied to the device. There were parallel searches that were conducted with these accounts tied to the device. So yes, there was overlap of the searches as conducted on this device.
Your Honor. Yes. This is, as you can tell from the people sitting at this table, we're having a little bit of a technical problem pulling the exhibits that we need for this witness. And that is obviously the fault of the attorneys, but we're having a little bit of a technical problem doing that. And I don't want to waste the court's time, and I don't want to waste the witness's time. And I'm wondering if it would be possible for us to possibly take an earlier lunch so that we can get these exhibits pulled, so that we can move through this, so that we can move expeditiously, which I think is our goal, Your Honor.
Certainly, if you think that's the best way to use our time, we can do that. It is about 11:30 now. Are you thinking you'd want to break until 1, or should we come back a little earlier?
I think 1 will make sense, Your Honor.
Okay, let's take our lunch break. We'll plan on resuming at 1 p.m. Thank you. Please sit down, Mr. Kessler.
All right, we're going to skip ahead, obviously, because we don't need to take the hour lunch break. Let me look here. Let's.
You're fine. Okay, we'll go back on the record. Mr. Kessel, you can return to the stand. I would just remind you that you remain under oath. Oh, sorry.
Your Honor, just more of a scheduling thing.
Okay.
I just mentioned this to Mr. Mullis' attorneys, but my understanding is there are 2 witnesses who have arrived in the courthouse who are here under subpoena, both from the Des Moines area. I just want to make sure that we accommodate them if possible.
Okay.
I want them to be accommodated as well. Kami Sadie says, I have now taken to playing with Sissy's tail to annoy her. I'm not sure that is a wise thing to do. I'm not sure that that's wise either. And if we don't hear from you after a little while, I'll be concerned. I don't know what I can do, but I will be concerned due to that. All right, here we go.
I guess, counsel, what are your thoughts about then how we spend our afternoon?
We feel the same, Your Honor. Our goal is to finish this witness expeditiously and move on.
All right, we'll plan on that. Ms. Steenson, you may pick up with your questions whenever you're ready.
Thank you, Your Honor. Mr. Castle?
Oh, I didn't mean to push.
Before break about the creation of Amy Lynn 5810 Google account. This was the Amy Mullis Google account that was only on her phone and not on the family iPad?
That's correct.
And from your testimony earlier this morning, this was the later created of the 2 Google accounts that you associated with Mrs. Mullis?
Her device, yes.
Do you know when that Amy Lynn 5810 Google account was created?
Without referencing the exhibit that contained that artifact, I don't recall off the top of my head.
With looking at the metadata TXT file from the extraction of Amy Mullis's cell phone, refresh your memory about? Okay, yeah, can you just show that? Do those guys need to think? Yeah, I'll show it. I'll show counsel what we are putting up. Working on.
Just as an aside, I'd like to take this opportunity to point out that whenever this kind of testimony comes out in trials, I have taken to my phone multiple times to Google or to look up my own information to see like when my Google account was created and all the things, just out of curiosity. All right, let's keep going because there's going to be some testimony coming up here briefly about triangulation of the cell phone towers in relation to some of I think the searches and where everybody or where these devices would have been located at the time that the searches were performed. I think I saw like when I skipped ahead. So we'll see what's coming up. I don't plan on entertaining this testimony too much longer, maybe another 30 minutes, and then we'll skip ahead to the former trial lawyer's testimony. All right, here we go.
To yourself.
Thank you.
Okay, you can remove it. Did that refresh your memory about the creation of Amy Mullis's Gmail account?
Yes.
And what was the date of that?
July of 2018.
And what was the, do you have the exact date?
19th.
Thank you. So July 19th of 2018?
That's correct.
Did you review or extract data from a phone connected to Mrs. Mullis's phone with the last four digits 5678?
Yes.
And 5675, I apologize. I misstated that. The last four digits 5675?
I believe that was the number associated with that other device, yes.
And do you recall when this data, the data on the phone started?
I don't.
Would it refresh your memory to look at a copy of the extraction
Yes.
data? Just one moment. I will have to bring this up to him. Yes. So.
Okay.
Did that refresh your memory?
Yes.
Mr. Kessel, when was the first earliest call on this phone?
July.
What was the date?
It was the 14th, if I remember looking at that. Was it July 14th, 2018?
Can I
Sorry.
approach the witness again to refresh? Certainly.
I apologize. It was July 22nd.
Does that mean that there was no data on her phone prior to that date in 2018?
No, there was data on the phone.
But no, what data would be available on the phone then?
The artifacts represent the activation of the device and the new call log beginning.
So the call from, was there, what data then was missing before July 22nd, 2018?
Sorry, I'm having a hard time following your question. You're asking me, first of all, when this number started being used as it was tied to which device specifically?
The cell phone that you extracted.
Okay. And
Let me re-ask the question. Based on the cell phone that you extracted for Amy Mullis, and your testimony today was that the earliest call on the phone was from July 22nd, what does this indicate to you?
the possibility of a factory reset.
Did you receive and review Google search history from a subpoena to Google showing Google searches associated with the Mullis RN Google account?
I did.
And did any of those searches search for the term related to the recovery of a phone?
It did.
And what does it mean to recover a phone?
The end user chooses to possibly reset the phone back to its default configuration due to troubleshooting steps or obfuscation of data contained on the device.
Is that sometimes? Can you tell me what you mean by that?
So troubleshooting, meaning that the end user was possibly experiencing some problems or issues with the device, and at the instruction of the carrier, they may have reset the device to solve those problems because a factory reset will put the software in a default configuration, which will eliminate a lot of problems. Or secondly, the obfuscation of data, meaning that they reset their phone to hide something.
The search you saw from the Mullis RN Google account relating to the recovery of an LG phone, do you remember when that search was from?
I believe it was in the July timeframe.
Do you know the specific date?
I thought it was around a couple days previous to the reset.
Would it refresh your memory to review the metadata files from the search of the extraction data of the Mullis RN account?
Yes.
Okay, I will show opposing counsel. There.
So this entry here, the entry right above it. So on.
Just review it.
Okay.
Do you have an independent recollection based on your review of that?
Yes, there was a search on the 20th of July, and then again earlier that day on the 22nd.
I would like to publish what has been previously admitted as
Exhibit 374, page 55, which is Amy Mullis's U.S. cellular phone records. Do you see this?
Yes, I can see the phone records.
Approximately what dates does this specific page cover?
From the 19th through the 26th of July,
In what year?
2018.
And this is, just for clarity of the record, this is page 55. Does,
Sorry, page 55 of the exhibit.
well, I'll just represent to the court that this is page 55 of the document, of exhibit 374. Does this phone record on this page show SMS activities associated with Ms. Mullis's phone?
Yes, it shows both SMS and MMS messages.
And can you tell me what that means?
SMS is signal messaging service for plain text messages received or sent from the device, and MMS is multimedia messages sent or received from the device.
Looking at this particular page, there is an SMS number that is shorter in length. Can you do like that? Can you tell me the date and time of that entry?
Yes, it's 3 or 4 p.m. on 7/22/2018.
And can you tell me what a short SMS code is?
It's typically used by carriers or subscribers to do a couple of things. One, either an advertising blast that would be received via SMS, or possibly a two-factor authentication code sent to a device for authentication purposes.
So this potential re-authentication or of a Google account was at the same day as a search on.
It's likely it's two-party authentication. If you have a YouTube channel and you are monetized, YouTube, i.e. Google, requires two-party or two-step verification. So say when I got my desktop and I set my desktop up and I logged into my Gmail account, because it is associated with my YouTube, it required two-step authentication. It's not, let's
on the Google,
get this going.
The Mullis RN Google account about recovering a phone.
Yes.
Did you review Mr. Castle, do you have experience with obtaining and interpreting cell tower location data?
I do.
Can you tell me a little bit about that experience?
Yes. In multiple cases that I have either offered affidavit or testified in, I have received subscriber intelligence data as pertains to call data records, per call measurement data, and other similar type signals information that allows me to triangulate and locate the handset of a given subscriber.
Can you explain in general terms what cell tower location data is?
Yes. There are several spreadsheets that are created as a result of the subpoena to the carrier of Verizon or AT&T that are given to the government in response. That data contains multiple items that are used to build triangulation and mapping of the handset. Those are the geolocations of the cell towers themselves and the pointed direction of the antenna on that cell tower. They are in a 120-degree grids, which would make a 360-degree grid array combined. And then with the call data records, as applied to the communications coming off the device, whether they be SMS calls or MMS, those signals are used to triangulate the location of the handset in relation to the cell tower at the time of that communication. That's as it pertains to call data records. Now, per call measurement data, which is a specific carrier term, is a measurement that is taken. Radio frequency travels at the speed of light, which is a determinate variable, and can be used to triangulate handsets. It is a more accurate measure of where a handset may be than called data records, as it is a radio frequency transmission communication between the handset and the tower itself. This information is more accurate simply because that measurement is taken periodically as the handset moves. As a general rule, mobile cellular handsets do not necessarily talk to the tower that is closest to it. It talks to the tower that has the best signal strength. So that has to be determined. That's determined by this measurement of the radio frequency and its signal strength in relation to the handset and the tower itself.
Good to know. There's an equation.
So
There's
just
math.
in a little more simpler terms, can the cell tower location data help an expert determine the location a cell phone was at the time it was in use?
Yes.
Did you review phone records of Jerry Frazier?
I did.
And where did you get this information?
I received it as part of the data I got from the government.
And what did you receive originally?
Originally, I received only a few pages or excerpts from these documents that would typically be turned over by the carrier.
I would like to show what has been previously marked as Exhibit 298.
Call me Sadie asked, did he even take a breath while explaining that? He probably did, but I have this sped up to 1.5, so it doesn't look like he took a breath, but I'm pretty sure he did. All right, here we go. I just want to hear about this Jerry Frazier situation, and then maybe we'll listen to a little bit of cross, and then we will move to the original trial attorney.
Mr. Castle, what is this?
This is a part of those batch of documents that I referred to that will be received from the carrier. This specifically talks about the geolocation of the cell tower and the direction that the gridded array would be facing.
The grid array?
Correct.
And this was provided to you originally in 2022?
Yes.
You can take that down. I would like to show what has been previously marked as Exhibit 299. Can you tell me what this is?
Again, this is an excerpt of what would have been a total data dump from the carrier containing data as it pertains to, as I stated earlier, the called data records of the CDR and SMS communications coming off of a handset.
And this is what, this also was previously, this was originally provided to you in 2022?
Yes.
Based on your analysis done with these two documents that I just showed you, what did you find?
My conclusions were incomplete because these documents are incomplete. I did not have all of the data necessary to do a proper triangulation or mapping of the handset in question.
Did you have, was there any data on November 10th of 2018?
No.
Did you ever review any other documents regarding Jerry Frazier?
At a later date, I was ultimately provided with all of the call data records and necessary information to build a more comprehensive mapping of the data, but this was after I had authored my original report.
Oh, who provided you that data? I need to know that. Are you going to ask that question? Because I need to know that question. Because I need to know if, because there was testimony in the original trial, because obviously, due to the affair, right, Jerry Frazier was a person of interest, and in my opinion anyway, his wife might have been or could have been or should have been a person of interest, right? So you would want to know where they were at the time and if they used their cell phones to verify their alibi, as it were. If the state only got partial information, then is it possible that they were closer to the farm or anywhere in the vicinity of the farm? So now I need to know all those things. Will we be asking about that, counselor? Because I'm curious. All right, here we go.
Would these documents, these that you were presented later, potentially change your opinion about whether it was possible to determine the location of Jerry Frazier's cell phone on November 10th, 2018?
If the data was not reflected for that date in particular, no, it would have not aided me in producing a location of the handset for that particular day. It did aid me in understanding where the handset may have been on all days previous to that.
I would like to publish what has been already admitted as Exhibit 271, page 11. Can you highlight the page just like here at the date of July 2nd, 2018, what is primarily being searched here?
The subject matter surrounding Ohana tattoos.
And were you aware of any communication regarding Ohana tattoos in the digital evidence that you reviewed?
Yes, there was a conversation in the communications between Ms. Mullis and another party surrounding her getting one of these Ohana tattoos.
I would like to publish what has been previously admitted as Exhibit 262, page 1. And looking at the top of, can you tell us what this document purports to be?
It appears to be the communications between Ms. Mullis and another party.
And at the, and can we scroll to page 7? Can you tell us what the date of this text message is?
This document would seem to reflect that the communications happened on July 2nd. It doesn't state a year in that time date stamp.
You can take it down. I would like to show the witness what has already been admitted as Exhibit 271 on page 57. Mr. Castle, you previously mentioned that you knew the iPad was activated on August of 2017. Why was this significant in your analysis?
It appeared that there were Google searches that were conducted previous to its activation.
And in looking at Exhibit 271 on page 57, can you tell us the date of the first search?
The first search that Google has record of for this account happened in March of 2017.
Mr. Castle, did you review the Galaxy DVR security cameras from the Mullis family farm?
Hold on. So I think what he's saying is that it's a little confusing because I don't know if the term activated means that is when the iPad was first set up, or if he's using the term activated to mean that it now has data available and not just Wi-Fi. I'm a little foggy on that, but let's see where this is going with the security system.
I did.
And did you perform data extraction on the security camera system?
I conducted my own independent collection or extraction of the data, and then I also conducted an analysis of the data contained within that hard drive image.
Can you tell me what your analysis and conclusions were?
After the proper procedures followed for the collection of that device, I took the opportunity to extract specifically the system's log file of that DVR, which reflected the communications of the cameras with the DVR unit itself. The cameras were a wireless connection to the DVR and reflected a number of disconnections over a period of time.
I want to break this down just a little bit. Did the system record any footage from October 29th, 2018 to November 11th, 2018?
I did not appear to have made a record of any recordings for that time period.
Could you determine whether any video footage was deleted during that time frame?
Yes, I was able to determine by doing analysis on the file system that there were no video files written for that time period, so there would not have been any files deleted for that time period.
Okay, that is important testimony. And if you missed the original trial or don't remember, which, let's be honest, it was a while ago, that's important testimony because it was, I don't think that it was, I can't remember if it was outright alleged or just simply implied that there were alterations to those cameras, meaning they were intentionally either disconnected or file or recordings were deleted. So there's that. Okay, here we go.
And can you remind me what program you used for this extraction and analysis?
I used FTK Imager to create the hard drive image, and I used DME's DVR Forensics, the same title the government used.
So this was the same program that was used by the state?
Yes.
Was there any activity on the camera at all between October 29th, 2018 and November 11th, 2018?
The log files reflect that there were a disconnect of the cameras from the unit itself.
Why would a security system stop recording?
Objection, calls for speculation and foundation.
Overruled.
The log files represent a connect and disconnect of the cameras, which again were a wireless connection to the base unit, and this connection and disconnection of the cameras to the base unit would be an explanation as to why there was no footage recorded at the time.
Did you learn through your review of the materials where the camera DVR system was located?
I learned from the materials, and also in September 2022 when I visited the Mullis family farm to retrieve a number of these devices I had opportunity to extraction on, I did a site survey to determine what building and office the base DVR unit was located in relation to the cameras that were on the hog barns independently.
And what was significant about having this knowledge?
It gave me a physical awareness of where the cameras were at in relation to the base unit itself.
So how did this impact your analysis and conclusions?
It was a further correlation that demonstrated the accuracy of the log files and their reflection that the cameras had disconnected from the base unit.
Did you review Mr. Hemeseth's testimony regarding the camera system footage?
I did.
Did he testify that he could not tell whether the camera did or did not record?
Objection, transcript.
Overruled.
Yes, I do recall that. He may have not had opportunity to look at the log files that I did.
Was his statements true?
Objection, this is improper opinion testimony.
Overruled.
It would appear that they did not have all the data necessary to make that conclusion.
Is your conclusion based on the data that you extracted?
It is.
And this is also the same data extracted by the state?
They had access to the data. I don't know whether or not they extracted or did analysis on that data.
But they had access to the system log to come to the conclusion that there was no data on the phones, on the cameras between October 29th and November 11th.
Correction leading.
Overruled. The answer will remain in the record.
Can I have a moment?
You may.
Oh, my stars. No, you cannot have a moment. Okay, we've heard about the cameras. So let's get to a little bit of cross-examination.
They had access to the data. I don't know whether or not they extracted or
Mr. Mullis' trial in 2019, could you have offered this opinion? All these opinions?
I've been retained by counsel for the purposes of analysis in these matters. My findings would be as they are.
Thank you. No further questions at this time.
Cross-examination.
Thank you, Your Honor. I'm going to pick up where we left off. Your testimony was that your findings would be as they are, right?
With the exception of the with the exception of the call data records and the mapping of the handset, yes.
So that means you used the existing software versions that were available at the time of the trial in 2018, and you didn't use any new versions of software. Is that right?
I did have a couple newer versions of software, but I did not reveal any additional data that I used as part of my findings.
So let's break that down a little bit. So you stated that you use several different types of software. So, for example, you use Celebrite, I believe Magnet Axios, and FTK, among others. So we'll use Celebrite as an example. Celebrite comes out with new versions of software as time goes on, right?
Often on a quarterly basis, yes.
And
on a quarterly basis, oftentimes, yes.
Thank you for clarifying that. So in those software updates, Celebrite would change how it extracts information from devices, right?
Sometimes, yes.
So, for example, it might change what encryptions it can break or new versions of iOS or Android that it can extract data from?
Yes.
And that would be the same for the other types of softwares that you use?
There are often enhancements contained within updates, yes.
And as part of those updates, they're able to extract more information as, for example, Android software gets older, they can find new exploits to look at that information, right?
Yes, that is true.
And if you use a newer version of Celebrite software, just as an example, you might get new or different information than what was available in 2018 based on old versions of Celebrite. Isn't that fair?
Hey, that is fair.
Okay, so evidently the state's contending that, look, we got what we got because we used the programs that were available at that time, and that's that. It's not that we didn't do an adequate job, a good job, a correct job. It's just that this was what was available to us at the time that we did our investigation. We shouldn't be penalized because there's updates that may have offered further information not available to us in our original investigation back in 2018, which is fair.
I guess continuing to work our way backwards through your testimony, you finished, towards the end, you finished off by talking about the Galaxy security camera system. So essentially,
good morning, Little Red. Good to see you, babe.
Essentially, you're relying on the logs to indicate that the cameras were never connected. Is that your testimony?
The cameras were disconnected for a period of time over the life of that DVR, and specifically in the time frame I was questioned about.
And you don't know why they weren't connected, right?
The log file represents that the wireless connection, as established between the main unit and the cameras, represented a disconnect.
So you don't know what caused that disconnect beyond that? Is that fair?
Until the physical inspection of the site, that would be correct.
So, for example, I guess I'll just say this. You don't know specifically what caused any disruption or disconnection of the cameras.
That's fair.
Thank you. In your report, you discussed the Galaxy camera software and the extraction done by the law enforcement officers. Is that right?
Yes.
And I'm turning to that section of your report, and do you have this report in front of you by chance?
I do not. I don't know that it was admitted.
Just to move this along, I'll read from it and just make sure that we're on the same page. So on page 11 of your report, you state, and just tell me if this sounds wrong at the end here, according to a DCI examination synopsis report, Deputy Hemseth attempted to access the security camera system without the proper software or extraction tools. Does that sound familiar from your report?
It does.
Do you now know that testimony or that portion of your report to be false?
Objection.
I asked if he knows.
What's the objection?
It assumes what it is saying.
What?
Overruled. You may answer if you can.
I'm unaware from trial transcripts or the report from DCI that former Deputy Hemseth had opportunity to review the log files as reported that I did.
In preparation for your testimony today, I believe you indicated that you reviewed Ward Crowley's report and his testimony. Is that true?
In part, yes.
In what part is it untrue?
I recall reading it. I don't recall the totality of it at the moment.
Were you aware that Ward Crowley specifically testified, which is in evidence here, that this is not what occurred?
In what aspect?
Were you aware that it was DCI Special Agent Ward Crowley who conducted this attempt of the extraction of the security camera system at the Sheriff's Office and not then Deputy Hemseth?
I do recall that aspect, yes.
So which in trials, semantics does matter. So what the issue is and what he's asking is, so you put it in your report that these security cameras were the sheriff's responsibility, and it actually was not. And so that's okay, I get it now. All right, here we go.
Okay, and then your report continues on to say that I'll just read it since you don't have it in front of you. You say, DCI agent Ward Crawley attempted to assist Deputy Hemiseth remotely while Hemiseth tried to conduct an on-site examination of this device at the sheriff's office. Does that sound familiar?
Yes, it does.
And you now know that that's not true based on the testimony and evidence here, right?
Hey, I'm sorry, which aspect of the testimony?
Well, you say in your report that Ward Crawley assisted remotely, but he testified in this proceeding that he was there in person, right?
Okay. That part of the testimony I must have overlooked. I apologize.
I'm sorry, you just testified that you reviewed his testimony, right?
I mean, but does that change anything?
In part, in that I don't recall every aspect of his testimony.
That's Ms. Yates' testimony. You're referencing a report here, and testimony is different than report.
Yes, you've admitted the report and the evidence.
But that's not necessarily what he's reviewed. And that's not his testimony today, that he's reviewed the report.
Your Honor, I think I can clear this up briefly. I'm
Oh,
referencing
boy.
the deposition of Ward Crawley, which is admitted into evidence here. Ward Crawley specifically explained how this extraction occurred. If they want to point me to something that contradicts that, I would be happy to revise my question.
Okay, and again, I think her point was that this witness maybe wasn't present at that deposition or wouldn't have that clarification necessarily. Let's just have a new question, please.
Thank you, Your
Right,
Honor.
let's just move on.
If I understood your testimony earlier, and I just want to get clarity on this, your testimony on direct examination was that you reviewed the report and testimony, which would only be the deposition from this PCR of Ward Crawley. Is that correct?
I had an opportunity to read that deposition. I do not recall the part where he was on site to do the analysis of the log files that were extracted specifically. My report in spirit reflects the fact that the log files about the connections between the main unit and the cameras were disconnected.
And maybe I can help clarify here. Do you recall any testimony from Ward Crawley in your review where he discussed attaching the physical right blocker device to the system?
I do recall that.
Okay, so would you agree that if he was attaching a physical device to the system, he would have to be there in person?
That would make logical sense, yes.
And there was some discussion in his testimony, without getting too granular, where he referenced using a trial version of the software. Do you recall that?
I do. I also recall during the course of that interaction that there was a phone call between the two of them regarding his analysis as well, and that may be what I was referencing when I was talking to the remote assistants.
Thank you for clarifying that. So you completed a report in this case, right? This is the general report of your findings that we've been discussing?
Yes.
Have you completed a supplemental or updated report correcting any of these discrepancies since this report?
No, I've not been asked to do so.
Okay, so now I'm understanding where we're going here. So if the applicant defense is making an ineffective assistance of counsel claim, basically they're saying, hey, if his original trial lawyers had retained a digital forensic expert, then some of the testimony presented by the state's witnesses at the original trial could have been refuted. And what the state is saying is no, because at the time of the trial, right, in 2018, they would have been just as limited by what they could get from an extraction of these various devices, cameras, et cetera, because their extractions would have been available to, would have been limited to the programs that were written at the time, for example, Cellbrite. And because it is now when he performed his extractions and the data and all that, that would have been in 2022. And so there have been updates to all of those programs. And so that changes what would have been available at the original trial in 2019 and or 2018 when the original analysis was done. So let's say when they did their investigation, it would have been at the state. It would have been at the time that this all happened, right? So it would have been, the end of 2018, beginning of 2019. Todd's trial wasn't until September of 2019. And they have to have, both sides have to have what they intend to use submitted prior to trial, okay? Because they have to go over it. And then there's, a lot of pretrial hearings about what evidence is admissible, not admissible, all of those things. So let's say his trial was in September. So like you could say August, maybe, that everything was finalized of 2019 and what was going to be admitted was going to be admitted. That's it. That's all. So there's what their state is saying is basically, even if they had, the defense had retained an expert, a digital forensic expert, let's say at the beginning, January of 2019, okay? If there had been an update done, which revealed more than what our original investigation at the end of 2018 revealed, we would have had an opportunity at that time to perform another extraction based on updates to the program files, right? And we would have, we would have probably gotten the same results. So what we're saying is this would have changed nothing in 2019. I understand. So Paul says there's nothing to suggest they couldn't have gotten the same data in 2019, i.e. the state points out no changes to software that would have impacted the analysis, which yes, I will agree with what Paul is saying. If you're going to argue, as the state is here, that updates, and he did elicit that testimony, right, from this witness, it would be helpful to point out that it would be helpful to know for the judge what updates, when the updates occurred, what may have changed. So it's kind of it should have been pointed out by the state which of those updates would have impacted the analysis, is my point. Did that come out right? I don't know. We'll see. Let's keep going.
I briefly want to talk about your background. At the beginning of your testimony, you talked about your background into digital forensics and network security consultant. Is that right?
Yes.
And you referenced dealerships as part of your background. That specifically is car dealerships, right?
Yes, in the automotive industry.
Okay, so your CV, where it indicates that you worked for example, Sid Dillon, Chevrolet, Buick, GMC, Cadillac, Mazda, Nissan, Hyundai. That's the example of your background working at dealerships?
That's one of them, yes.
Okay, and then you worked for other car dealerships?
Yes.
You don't dispute that the Google searches that all of the Todd Mullis Gmail searches that were in evidence had to have come from some device connected to a Todd Mullis Gmail account, right?
Can you rephrase?
Yes, it was poorly phrased, I'll admit that. Just for clarity, we have the Google subpoena results, right?
Correct.
You're not disputing that all of those searches came from something connected to that account, right?
Correct.
And you have no way to know who specifically is on the other side of those Google searches?
Yes, that would be correct. Attribution in its truest form and understanding the patterns of usage and searches conducted. Unless there was someone that could visually witness the searches being enacted, it would be difficult to tell who was responsible for them.
Fair enough. You had some testimony about the correct meaning of UTC time, right?
Yes.
And although you referenced Deputy Hemeset getting that wrong in his testimony, you also had difficulty converting UTC time today, right?
I did.
Just so we're clear on the issue of the dish DVR, you can't specifically say what show is watched on what day in this case, right?
By the correlation of the TV guide and the unit itself, it's still some difficulty in producing the exact date in which some of those videos were watched. You are correct.
And would it be fair to say that shows can be re-aired?
Absolutely.
For example, hold on a minute. For example, the Andy Griffith Show. Obviously, that show is not a current show, and so any show that it's all a rerun, right? But there are reruns of the reruns. So, okay.
I'm sorry, one follow-up on that. You also don't know who is watching the show that would be on, right?
Correct.
Thank you. If you can just please clarify something for me. You referenced based on user synchronization options.
I'm going to rewind this question, but this is an important point that Paul makes. Paul says, remember that in the original trial, Hemeset testified that the searches came from the iPad. He didn't understand that different devices connected to the same Gmail could have made those searches. And that makes a difference. That is important testimony to know which device it came from specifically, because while everyone in the family may have had access in theory, right? Not that they were necessarily in the home to have this access at the time, but theoretically, everybody had access to the iPad, right? Whereas not everybody in the family may have had access to, say, Amy Mullis or Todd Mullis's phone. So that is important testimony, and the details in that do make a difference.
The searches can show up on other shows. It'd be fair to say that shows can be re-aired.
Absolutely.
You had a reference to, or I'm sorry, one follow-up on that. You also don't know who was watching the show that would be on, right?
Correct.
Thank you. If you can just clarify something for me, you referenced based on user synchronization options, the searches can show up on other devices. Can you just explain what that meant?
Yes. When you sign into, as an example, the Google Chromium or Google Chrome web browser with a Google account, you are presented with options. Those options would be to synchronize those searches and history on that account with that browser. So there is a way to opt in or opt out of that synchronization happening across those multiple platforms and devices and browsers.
And are you aware if
For example, because I use Google Chrome to search on both my iPhone, my iPad, and my desktop, they're all linked. They're all synced. That's because I'm lazy. Okay. And sometimes I move from device to device depending on what I'm doing during the day, where I'm at, blah, 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 et cetera, et cetera. You don't have to do that. It's not required for you to do that. It's just me. I'm lazy. And sometimes I will do a search on my phone, right? And then I'll get the results that I want. I might be working on a video and I'll remember, oh, hey, I searched this before, or I read an article before that I want to reference in a video that I made. And I can go back if I'm on my desktop while I'm working on said video, because I don't work on videos on my phone or my iPad, right? I can go back. I can go to my desktop and go back through my Google search history and bring back up that specific search that resulted in that article coming up, and then click on that link. It's for ease of access, i.e., Jinlu is lazy. I don't know. Maybe I'm not lazy now that I think about it and I have it laid out like that. I actually think that might be smart and I might be efficient. I'll have to ponder on that. Let's continue.
User synchronization options were enabled or disabled on the various devices here?
No.
You testified on direct examination that the correlation of Google searches seems pretty straightforward and obvious, or something to that effect. Does that sound right?
The correlation of the Google searches to other data points available to me as part of the investigation does outline a pattern.
So if it's straightforward and obvious, we wouldn't necessarily need an expert to tell us that part?
But I would agree with that.
You spoke about
He's right. If it is straightforward and obvious, you wouldn't necessarily need an expert witness to point that out. However, if you're the defense at the original trial, if you don't look and do a little digging, right? You'd have to do a little digging to be able to point that out. Even if something is obvious and straightforward, if you're not looking for it, you're not going to find it. So it makes no difference whether it's obvious and straightforward or not.
Mullis's phone possibly being reset, but you don't have any firsthand knowledge of why the phone was reset, right? In other words, you weren't personally there to know why?
Correct.
And because I believe you testified that it could have been for a variety of different reasons, right?
Correct.
So you can't say definitively why it was reset without speculating, fair?
Okay, so Call Me Sadie says, I watch YouTube on my TV. However, I chat or watch other things at the same time. It asks me if I want to sync the TV and phone, and I always say no. So usually when I get that pop-up, it has to do with actually casting what I'm watching on my phone to my TV, in which case I say no, because I don't need to. And Paul says, how about Crowley doing some of the data extraction when he was the one who had what? How about Crowley doing some of the extraction data when he was the one who had the affair with Amy? What? Paul, when does this testimony come out? Oh my goodness. Yikes on bikes. Here we go.
Analysis of web history and searches happening up until the point of that reset would offer some insights into the possibilities.
You also testified about your experience working with cell phone records, extractions, location data, that type of thing, right?
Yes, I did.
And you described for us what SMS and MMS messaging is?
Yes.
Would it be correct in saying that SMS actually means short message service?
It's another acronym that's synonymous with the messaging style, yes.
Looking at the VOLTE records for Mr. Frasher, would it be fair to say that there would be a tower code in the column of those documents?
Without looking at it again, I'd have to refresh my recollection.
I can try.
Wait. Paul says he was the officer who had the affair with Amy came out during Hemaseth's testimony. Now, I thought the guy's name was Keith, not Ward. Oh, I'm gonna have to go back. Here we go.
To do that, give me 1 moment.
Keith or Kyle is what I thought. Did I miss it?
I guess I'll speak generally without getting specific. Would it be generally true that documents would, or excuse me, that CDR records might have a column that indicate what tower was being connected to?
Oh, absolutely.
And based on that tower code, would you agree that anyone, if they know what website to go to, could figure out where that tower is with some effort?
As far as like just putting the latitude and longitude coordinates into a browser to determine its location?
Going the other direction, is it possible to take that, say for example, just hypothetical here, that we know someone connected to a US cellular tower and we have a tower identifier. Is that something someone can take and figure out where that tower is?
It depends on the public records release of the carrier for those locations.
Okay, so Paul says, oh, do I have my people mixed up? I think so. Look at me. Look at, I was correct. Clicker says, Paul, Bindi is correct. Keith Rowley was the officer's name. Keith Rowley. I thought it, wait a minute. Okay, but it was Ward Crowley who did all the data extractions. We need clarification on this. Clicker, I'm summoning you to the front of the front of the classroom, please. Because he said Crowley. And the only reason why hold on. I'll wait. I'm going to push play, and then when we get clarification, I'll clarify it. All right, here we go.
Is it possible?
In this random number generator of a universe we live in, anything's possible, sir.
Fair enough. I want to direct your attentions. You discussed doing, in addition to your general report, you did reports of various extractions of devices, right?
I did create reports of specific communications or data points out of some of the devices I did extractions on, yes.
And one of those reports that you did, I believe you titled New Conversation or New Convo Report. Does that sound familiar?
It does.
And would that be in reference to Mr. Mullis' cell phone?
Without referencing the document itself, I'm not recalling specifically which communications those are referencing.
And I can attempt to plug this in here so you can take a look at it, and this will be just for the witness, Your Honor. Yeah, it's the instruction. Let me know when you can see my.
Okay. So, okay. Clicker says, I have my sticky note from the original trial right here, Keith Rowley. Right. But what Paul is saying is that Crowley, Ward Crowley, who performed, look, this is what Paul said. How about Crowley doing some of the data extraction when he was the one who had the affair with Amy? That's the question. Clicker. That's the question. All right, here we go.
My screen here.
I see a source extraction data in regards to a phone.
And this is your name up at the top here, is that right?
Yes.
Okay. I'm going to scroll through this briefly. I just want to make sure we're talking about the same document here. What would you need to see to identify what device this was from? So it mentions the selected device name.
underneath the device name and manufacturer. And it also, oops, I'm sorry, the documents, sorry. So it gives a general idea of the device name there and the brand. Is there another page that gives more specifically the IMEI or some other unique identifier for the device itself?
I'm sorry, I was being asked just a clarification question from counsel. Can you just state that again? I just want to make sure we're on the same page.
Okay.
Okay. I think we're all on the same page. Okay. So here's the deal. Keith, Rowley, Rowley, is the officer with which Amy had the affair. Ward Crowley, Crowley, is who performed the data, the extractions on the various devices. Two different people. I think I got it. We cool. All right, let's keep going because I really want to get to the attorney from the trial. In fact, let's skip to where it's most replayed because obviously when things are most replayed, when you look, I don't know if you guys can see this. Yeah, you can. All right. So you see where here it has the thing most replayed 541 timestamp, but you can see prior to that, there's not anything like that. Like, see, look, 541. So if you go back here, it doesn't really do that, right? That means something there is important in the trial typically, or the video itself. And so that's where we'll skip to, and we're already in cross-examination. So let's go here and see what it is that people, why they replayed this the most out of this entire 7 hour and 34 minute and 40-second video. And the having no sound is not anything that is me. It's the video. Why is there no sound? How can this be the most replayed if there's no sound?
To
What's that message about? Not that give the full.
I say when the sound comes back. There we go.
An unknown reason.
Oh, technology. No, clicker, you're fine, babe. Who knows what this is? This could be highly, hugely important. This could be bombshell testimony, but we don't know.
An unknown reason, they were not able to fully process the data. Therefore, the DDR was submitted to my office for further examination.
Can I have just one moment? Certainly.
First of all, can you hear me? We'd like to read into the full content of that message that the state just read into the record, or the full message in response to it, so if I can do that. Or we'd like to offer again the text message between Todd and Amy Mullis that give the full content of that message, because this is just a snippet of the extraction, not the full extraction. So we would just like to provide the full context of what that message is about or not.
Your Honor, I apologize, but I'm confused. I believe the exhibit I read from is already in evidence. Is counsel intending to read from a different portion that's already in evidence? I'm unclear.
I guess I'm not sure. Are you planning on reading or asking to read from 307?
307.
And I guess for just clarity of the record, briefly, I wasn't intending to testify when I read that message in. It was only because it was obstructed from an exhibit number, and the e-filing stamp was the only reason I read it that way.
Well, is the reading attached to a question for this witness or not? Sure. I mean, is it being read because there's a question that goes with the reading, or?
I think our argument is that we just want to have the rule completeness, that the whole text conversation is considered as a whole instead of just that one isolated text message. And so,
well, okay, and so that's my job in reading the exhibit, which I will do. You know, we've put this witness through a lot of hours of testimony, and so I think right now we need to focus on what questions we have for this witness.
Yes.
And so he doesn't need to read that whole exhibit unless there is a question for him.
yes, Your Honor.
Okay.
May I resume?
Yes.
Based on your review of the digital forensic data, were you able to determine that multiple devices were logged into Todd Mullis 76 Google account?
Yes.
I think we already talked about this. Let's
And
go
so
ahead.
would they-
Let's get to what we want to really hear from.
Mayor, you can sit comfortably. Ms. Nichols-Cook, whenever you're ready.
Good afternoon.
Good afternoon.
Could you please state your name for the record and spell your last name for the court reporter?
It's Gerald Burton Firehelm, Feuerhelm.
And do you also go by Jake?
Yes, prefer that.
Have you previously been deposed regarding your representation of Todd Mullis?
Yes.
And did you previously sign an affidavit regarding this case?
Yes,
And are you an attorney?
I am.
Have you always practiced in Iowa?
Yes.
What area of law do you generally practice in?
Almost exclusively criminal defense.
In general, how many years have you been practicing?
46, 45 and a half.
Has the type of evidence in a criminal case changed in any way between the time you started practicing in criminal law till today?
Yes, lots of technology.
And are you employed by a firm, or do you have your own firm? Where do you work?
I'm a PC, but I'm the solo attorney.
Okay. Have you ever had a legal assistant or support staff person work with you?
Yes.
When you represented Todd Mullis in 2018 and 2019, did you have an assistant?
Yes.
What was her name?
Christy Klein, Klyn.
What types of things would Christy do for you?
Everything from answering the phone, scheduling appointments, accumulating and organizing discovery materials. Pretty broad section of what she did.
Over your decades of experience in the criminal law area, have you represented individuals charged with Class A felonies?
Yes.
Do you know approximately how many of them went to trial?
8 or 10.
In your experience, have you ever consulted with an expert witness for the purposes of representation of a person charged with a Class A felony?
Yes.
Have you consulted with an expert about determining cause of death?
Yes.
Have you consulted with an expert regarding digital forensic evidence such as cell phone extractions or cell tower data?
Both.
How often have you used an investigator on a Class A felony?
I would say about half of the cases.
Do you belong to any bar associations?
Iowa State Bar Association, Iowa Association for Justice, and the National Association of Criminal Defense Lawyers.
And are you aware of the American Bar Association?
Yes.
Are you aware that the American Bar Association has issued a defense function standard?
Yes.
Would you agree with me that the prevailing standards for defense attorneys recommend that you continue to reevaluate your need for investigation or experts?
That sounds correct, yes.
I want to turn now to your involvement with Mr. Mullis.
Okay.
How did you come to meet Todd Mullis?
An attorney in Dubuque, I believe, his name is Joey Hoover, who practiced in Polk County, and I knew him from there. I don't know how he knew Mr. Mullis or was connected to him, but as I understand it, Joey had contacted a friend of mine, Roger Owens,
who I've tried Class A's with on several occasions, and wanted to know if Roger would be interested in getting involved in Mr. Mullis's case. Roger contacted me and said he didn't want to take a case so far out of Des Moines. Thank you. And encouraged me to call Joey about it, and that's how it came to be.
Thank you. At the time that you learned about Mr. Mullis's criminal case, do you recall if he had been arrested or not?
I believe he had.
Did you meet with Mr. Mullis and enter into an engagement letter or anything like that?
I think the first thing I did is I made arrangements with his sister and brother to go out to the farm and have them show me the location of the incident. And I talked to Lynn about whether or not they wanted to retain me. I had not yet met with Todd.
Do you know Lynn's last name?
I'm not sure.
If I told you it was Lynn White, would you?
That was going to be my guess.
Okay. Was there another attorney that you worked with on Mr. Mullis's criminal case?
Bob Sabers from Dubuque.
Had you ever worked on a case with Mr. Sabers before?
I'd never met him.
Never even met him?
No.
How did you communicate with Mr. Sabers as co-counsel?
Probably equally phones and emails.
Do you know how often you talked to Todd Mullis while his criminal case was pending?
I really couldn't even guess.
Do you know if Mr. Mullis would call you from jail?
I believe he did.
And was your office set up to accept those types of calls?
Yes.
Do you know if Mr. Mullis sent you letters or wrote notes to you?
Letters mostly.
And I think you mentioned earlier that one reason you'd gotten the referral was because it wasn't that close to where your office was, or it wasn't that close to Des Moines.
Well, Roger Owens didn't want to get involved because this location he didn't want to travel that far to represent somebody, and I was willing to do that.
Do you recall what county Mr. Mullis was being held in?
Independence, I believe. I think that's Buchanan, maybe.
Did you have a regular practice or policy of how you communicated with your clients that were incarcerated?
I prefer meeting them in person, and the jail over in Independence accommodated that, and those phone calls.
Did you speak to Mr. Mullis once a week or once every 2 weeks? Did you have any sort of regular schedule?
I don't think we had really a schedule. I think it would be like if something came up on my end, I would set up a phone call, or if he sent me a letter that had some request or a question in it, I'd respond to that either by a visit or a phone call.
Do you recall ever writing Mr. Mullis letters and sending them to the jail?
I don't think so.
Was it your practice in this case to take internal notes about visits or phone calls with your client?
I'm sure I did, and maybe not every time, but yes, I did.
And did you provide your file to subsequent counsel?
Yes, I did. I just gave everything I had to Aaron Hamrock and Tim McCarthy.
I think you have seen some of these letters in your deposition, but just so that we're all on the same page, I'm going to ask that we display Exhibit 233. Are they showing?
No.
Okay. And we can scroll for you when you're ready. I think that one has several pages. I don't want to rush you, but do those documents appear to be letters from Todd Mullis to you?
I believe they are, yes.
Do you recall reviewing these letters during your representation of Mr. Mullis before his trial?
Yes.
And am I understanding correctly that your response to any questions Mr. Mullis had would have only been relayed to him in person during a visit or a phone call?
I believe so.
I want to just look at the very bottom of page 1 of 233, the last paragraph. That should be the bottom of page 1. Do you see a paragraph at the bottom of page 1?
Is there any expert that starts out?
Yes.
Yes.
Do you recall Mr. Mullis asking you about an expert to be used in his defense?
Well, that is posed as a question there.
Okay.
Yes.
And at this time, what was Mr. Mullis's position as to how his wife had died?
He believed it was an accident.
And could this paragraph in this letter be him asking you to get an expert to show it was an accident?
Your Honor, I'm going to object on a couple things. This is one of the exhibits specifically that we had objected to: authenticity, accuracy, identity, or foundation. The letter's undated. It specifically has no identifying information as to the date, time, or otherwise. And also it's hearsay because Mr. Mullis' statements are not statements of a party opponent and therefore are being offered directly to in violation of Rule 5, 802, and 3.
If there are objections to the exhibit, it should probably be admitted before it's specifically referred to. Would you like to respond to the objections?
Sure. Thank you, Your Honor. We've laid some foundation that Mr. Firehelm received letters from Mr. Mullis from jail. He identified these as being letters that he remembers receiving. I could ask Mr. Firehelm the dates of his representation. I do think the record reflects when Mr. Mullis was arrested and when he went to trial. And I guess I don't see how 802 and 803 would prevent a request from a client to his attorney when that is the claim on post-conviction of ineffective assistance of counsel that we have the burden to show. And I have to elicit evidence about what Mr. Firehelm did or didn't do.
I assume these are being offered to show the effect or lack of effect, perhaps, on the reader or recipient. 233 is admitted.
Thank you, Your Honor. Mr. Firehelm, did you understand Mr. Mullis to be asking you to hire or retain an expert to determine if you could put on evidence that Ms. Mullis died in an accident?
I don't know if excuse me. I don't know if I characterize it as a request. It reminds me, that paragraph, of a number of times when, to me, it was like Todd was kind of like shotgunning or spitballing ideas of what about this, what about that, and so forth. So I don't know if I would say that that was a specific request, more of a what about this, or how would this be something to think about or talk about.
Did you contact any experts regarding the manner of Amy Mullis's death?
No.
Did you review any literature or do any investigation into an accidental manner of death?
I reviewed discovery material, which included the manner of death, to allow me to assess whether or not it was an accident or homicide.
And outside of the discovery materials provided to you by the Attorney General's office, did you do anything else?
Excuse me. I just need to take a moment to pause for fair use commentary and to also address what Jake, as he likes to be called, just testified to. So he was asked if he did any research and investigation into the accident theory. And he said that he reviewed the medical examiner's report. Well, as to the cause and manner of death. Jake, let me just go a little Nancy Grace on you. Let me refresh your recollection. If it had been classified an accident, you wouldn't have been retained, sir. Perhaps what you meant to say is you reviewed the medical examiner's autopsy report in an effort to understand why it had been classified a homicide. I'm not real sure, but that testimony wasn't it, sir. All right, here we go. Hold on a minute. Let's
review any literature
to think about or talk about.
I mean,
Todd was kind of
determine
perhaps on the reader or recipient.
Let's hear this again.
Thank you, Your Honor. Mr. Firehelm, did you understand Mr. Mullis to be asking you to hire or retain an expert to determine if you could put on evidence that Ms. Mullis died in an accident?
I don't know if I excuse me. I don't know if I characterize it as a request. It reminds me, that paragraph, of a number of times when, to me, it was like Todd was kind of like shotgunning or spitballing ideas of what about this, what about that, and so forth. So I don't know if I would say that that was a specific request, more of a what about this, or how would this be something to think about or talk about.
Also, I would just like to say, hey, okay, Nate Noodle, I'm bummed that you got to go to your appointment and won't be here, but have a great appointment. I don't know what it's for, and I'll see you in a little bit. Bye. Thanks for being here, by the way, babe. I appreciate it.
Did you contact any experts regarding the manner of Amy Mullis's death?
No.
Did you review any literature or do any investigation into an accidental manner of death?
I reviewed discovery material, which included the manner of death, to allow me to assess whether or not it was an accident or homicide.
And outside of the discovery materials provided to you by the Attorney General's office, did you do anything else?
No other materials or individuals, no.
If we can scroll to page 2.
Okay, upon further review and re-listening to that question and answer, I think what he's testifying to is the latter, that he reviewed the discovery materials and autopsy report to assess whether it could have been an accident. I think that's what he's saying. It's a little bit unclear. I would have liked more clarification, but they don't ask me these things. They don't consult with me, which is a shame because I have a ton of suggestions. Here we go.
In the middle of the page, there's a sentence that refers to looking at the clothing.
Yes.
Is this a request for you or a question for you about examining Amy's clothing that she was wearing when she was injured?
I guess my answer would be similar. I don't know if it's a request or just an idea.
Okay. Did you ever go look at the physical items of clothing that Amy was wearing on November 10th?
I did not. I don't know if Bob did or not.
Okay. I would never ask you to tell me what Bob said.
Okay.
What did you understand that there were 3 items of clothing that the state medical examiner had looked at during her autopsy?
I think that's right.
If you go down a little farther on the bottom of page 2, there's a reference about iPads and Amy using the iPad. Do you see that?
Yeah. Yes.
Where in there?
It's kind of around the highlight in the very it's not a paragraph, but towards the very end of the letter. Amy used that iPad.
Is this page 5 of the exhibit? Got it. Thank you.
Do you see the portion I'm referencing, Mr. Fireholm?
Yes.
Just a minute, okay. I apologize. I am definitely fighting off a cold. Mr. Fireholm, was the iPad a piece of evidence at Mr. Mullis's trial, or the data from the iPad?
I think the data was.
And what did you do when your client brought up the issue of the iPad and who used it to investigate that?
Well, here he was mentioning multiple people using the iPad. I believe that's something that Bob and I either talked about or traded emails about. I think I saw one where Christy maybe responded to one of Bob's questions about that.
Did you interview any witnesses about who had access to the Mullis family iPad?
Just Mr. Mullis, I think. Maybe Lynn and I may have talked about that too.
Did you take any steps to learn about the password to the iPad?
I don't recall.
Just one moment here. I think I'm done with 233 and we can take it down. Mr. Fireholm, you mentioned you spoke with Todd's sister, Lynn. Do you remember how you communicated with her during your representation of Todd?
I'd say a vast majority was by phone, and there were some emails.
Was she also in communication with Todd while he was incarcerated?
I think she was, yes.
Do you recall her reaching out to you with requests to meet with Todd?
Lynn was good about reaching out to me after she talked to Todd about either him wanting to talk to me or see me, or maybe even a specific thing he wanted looked into or checked on.
I'm going to represent to you that Todd was arrested at the end of February 2019. Do you know what your first task was after you were retained and began representing Mr. Mullis?
I think my trip to the farm to meet with Mike and Lynn was the first thing.
Okay. And then did you file any motions or take any action in court?
From the get-go, there was a lot of effort put into trying to get Todd out of jail with bond review. I spoke with the bail bond company in Des Moines that I was familiar with and had worked with, talked to Todd, Lynn about resources to acquire a bond.
And would that work have been separate from investigating the charges against Mr. Mullis?
Yes.
Do you recall a time where you requested discovery from the state of Iowa?
I don't know the time, but that probably would have been one of the first things that I did.
When discovery came into your office, what was your process?
I would review it, at least scan it. I don't mean scan it like to copy it, but to look at it, and then talk to Christy. And then Christy was great at organizing, setting up tabs, indexing things, that kind of thing. And then I'd go back and go through it after she had that organization completed.
Are you a paper guy? Do you like hard copies?
She called me the tree killer. Yes, I prefer
I'm
paper.
sure she meant that with all the love.
No, I prefer paper.
So did Christy handle compiling discovery that was tendered to you in an electronic format and making it into paper for you?
Yes.
At the time that you went to trial in September of 2019, did you know if the state had withheld any discovery, or did you identify anything that was missing?
I did not identify anything, and I was assuming the state had produced what they were supposed to.
If we can put up Exhibits 201, I believe you saw these in your deposition. I'm going to show you 201 and 202. Just let me know when you have had a chance to look at 201.
Okay.
Do you recognize that document?
I believe Angela showed this to me in my deposition, and I don't think I do.
And do you remember testifying in your deposition that you'd never seen it before Todd's criminal trial?
I think that's correct.
And we can scroll through it if you like. It's only 2 pages, but does this purport to be case log notes from the state medical examiner's office?
Yeah, it looks like it.
And I believe 201 and 22 are already admitted. Did you learn that the state medical examiner had made comments to DCI that Amy Mullis's manner of death could have been accidental or a fall?
Objection mischaracterizes the evidence.
Counsel, I guess, would you like to rephrase your question, or do you take the position that that's an accurate summary of the statement that was made?
I can withdraw the question and ask another one if you'd like, Your Honor.
Thank you.
Let me just find the spot here. Okay. If you look at the bottom of page 1, there's a paragraph under November 14th, 2018. Do you see that paragraph?
Right now, the witness has page 2 in front of him. So
page 1, please.
What date did you say?
It's towards the bottom of the page, November 14th, 2018.
Oh, yeah, I see it.
So if we go down towards the bottom, there's a sentence that begins, Agent Turbot stated.
Yes, I see it.
If you read that, is that new information to you about what DCI was telling the medical examiner?
I think it is, yes.
Okay. And is that type of information that you would have wanted to know for your cross-examination of the state medical examiner?
Sure.
Could it have explained where she was getting her information?
Yes, but in other homicide cases that I've been involved in, I've seen this type of exchange between the medical examiners and like a lead investigator. But I just don't think I saw this one.
Okay. We can go to 202. And Exhibit 202 has also been admitted, and it is 2 pages. If you could review that, I'll just ask that we scroll slowly. Mr. Firehelm, do these also appear to be notes about conversations with the state medical examiner?
That's what it looks like.
Okay, and does this, and we can scroll for you if you like, that contain information obtained from the autopsy about injuries?
It appears so.
Does it indicate how long Ms. Mullis would have survived after her injury?
I don't see anything like that on page 2.
I think it might be page 1 at the very bottom.
Yeah, it says, so hard to tell how long she was alive, at least minutes she was alive, not immediately fatal.
Would you have wanted to have these notes available to you at trial to cross-examine the DCI agent, Mr. Turbot, who provided this information or made these notes?
Yes.
Does it also discuss whether Amy Mullis's injuries could have been from a fall, or if so, why not?
There's indications in there about whether it was accident or intentional.
And Mr. Firehelm, the first time you saw these documents was during your deposition in 2023?
I believe so.
Okay, we can take that one down. Do you remember the name Deputy Keith Rowley?
I don't recognize that.
Have you learned, I'm sorry, Mr. Do you recall the state filing a motion in limine pretrial to limit the use of a deputy's name who had a prior affair with Amy Mullis?
I'm pretty sure I remember that, yes.
Did you ever learn who that deputy was?
I think we knew the name, yes.
Did you ever receive any documents or information that Deputy Rowley was cleared as a suspect from being involved in Amy Mullis's death?
I don't ever remember seeing any documentation.
Do you remember hearing anything in depositions about clearing Deputy Rowley?
There might have been. The only thing I remember specifically about depositions in that issue was how the case was assigned within the sheriff's office for investigation.
Do you recall seeing any patrol logs for any of the sheriff's deputies from Delaware County on the day that Amy died?
I do not.
Do you recall seeing them during your deposition?
The one of my deposition?
Yes.
I don't recall.
Okay, I need to pause briefly for commentary under fair use purposes. So Paul emailed me Friday and had notes, and which I greatly appreciate. But one thing that I want to talk about just briefly, really quick here, is that Todd has 2 claims in this hearing. Okay. 1 is the ineffective assistance of counsel, and 2 is an actual innocence claim. And so one of the things that Paul wrote me in his email was that the defense hasn't done a great job at differentiating which evidence goes to which claim. Does it go to the ineffective assistance of counsel? Does it go to the actual innocence claim? Does it go to both? Right? And so I think I just wanted to point that out. And I'm going to do a better, more comprehensive recap tomorrow morning before we start the day 5, just to let you guys know. All right, here we go. Also, hey, Alicia, good to see you, babe. And she brought snacks.
I'm going to pull those up for you. I lost the number, so I apologize for the delay. Okay, should be Exhibit 323. Let me know when you have a chance to look at that, Mr. Farrell. Mr. Farrell, if you could scroll through 209 a little bit. It's 12 pages. And when you're ready, let me know what you see.
It looks like a log that a deputy would maintain about activities on their shift.
And at trial, in preparation for trial, would it have been helpful for you to know whether other people were near the Mullis farm November 10th?
It's helpful to have as much information as you can, and that was something that we talked about.
So now this would be important, right? For a couple of reasons. One, well, for one reason, because I think they're just asking, hold on, let me go. Stay with me here, okay? Give me just a second. Not all the synapses are firing apparently correctly at this time. But just in general terms, would it have been helpful to know who was near the Mullis farm at the time of the incident, right? That would be helpful to know, particularly because, as we know, during opening statements, Mr. Jake here said that this was a murder. So maybe if he had reviewed that and looked at that, and maybe there wasn't anyone that Amy or Todd knew or had some kind of dealings with, right, near the farm, then maybe it would have spurred this attorney on to actually investigating an accident. But yeah, I forgot where I was going with that. I got totally distracted. Here we go.
Okay, we can take that one down. Did you hire an investigator to help you investigate or to represent Todd Mullis?
Did not hire one.
Do you remember who Jerry Frazier is?
Yes.
Before trial, did you know or investigate where he was on November 10th, 2018?
Yes.
How did you know that?
From discovery material and his deposition.
Okay, I want to show you Exhibit 212. Should be Frazier cell phone record. Oh, I'm sorry, we don't have 212. 213 and 214. Let me know when you've had a chance to look at 213.
Yeah, that's the cover page of report.
Have you had a chance to review that?
Just a couple of quick things. First of all, I need to know who quoted Ronnie Coleman, Paul, please. I need to know that. Also, it seems like from what we've heard at this point anyway, right? Because we still got quite a bit of testimony. There's another day of his testimony for sure. All he used was the discovery materials. It doesn't seem like he did his own looking into things, as it were, which, Alicia said, yeah, buddy. Thank you, Paul. It seems like he just only used the materials provided to him through discovery. Like there wasn't an independent defense investigation conducted, nor did he consult with anybody to do any type of investigation. This is highly irregular.
I don't recall seeing that document.
Okay. Do you recall being asked about cell phone tower records or cell phone records for Jerry Frazier in your 2023 deposition?
I think Angela asked about that.
Do you recall saying that you were surprised to hear testimony about Frazier's location by cell phone tower?
If that's what I said.
Would you like to review your deposition?
Sure, I don't remember that question and answer.
If we could pull up 323 and scroll to the bottom of 42. And if you could review page 42 and 43.
Okay, I do kind of remember this now, yes.
Okay. Do you recall at Mr. Mullis' criminal trial making arguments that Amy could have been killed by Jerry Frazier because of their affair?
I don't remember that specifically, but I could have.
You did. So Paul says 100% Jen, he did no research at all, not a shred of evidence to support Todd's testimony, e.g. copy of the Hunter test that his daughter took. They just relied on Todd to be their defense, which in and of itself is problematic because it is always a dicey proposition to have the defendant testify. It very rarely is successful. I mean, it has been successful. It's not like it never works, but it's not the best trial strategy, especially because in this case, they weren't arguing that it was self-defense. I mean, typically when the argument is self-defense, the jury certainly would like to hear from the defendant in those situations. And I think the defendant themselves is in the best position to explain why and what the circumstances surrounding what they're purporting to be self-defense and let the jury weigh it out. It's still, even then, a very dicey proposition to put a defendant on the stand. And if you are going to put a defendant on the stand, unlike with Sarah Boone, because that putting her on the stand was going to happen anyway, but the order in which it happened had to occur because of a prior ruling during pretrial and then pretrial motion. So her case, hold on just a second. Her case is a little bit different, but certainly if you're going to put the defendant on the stand, right? You would want to have other witnesses independent of the witnesses that they put on, which were Todd's family, which those are good witnesses, and they can speak to what they witnessed. But at the end of the day, I'm not saying that these witnesses were not honest. What I'm saying is, in a jury's opinion, in a jury's mind, in a jury's eyes, which I have to say, I watched this case from a juror's perspective. I didn't know anything about this trial when it happened. So if I were sitting on that jury and I listened to their testimony, while I felt their testimony was credible, I would probably give their testimony a little bit less weight, because they have a motive to be less than honest. They have a motive to represent things in a certain light, because that's their family member who is on trial. So it would have been really helpful for the defense to put on expert witnesses. I just don't understand why they didn't.
Do you recall your closing argument at the criminal trial?
Not any details, no.
Do you recall whether you argued to the jury that Jerry Frazier was the perpetrator, not Todd?
If that's what the transcript says, I would obviously deny it.
Okay, let me ask a different question. In your mind, leading up to Todd's trial, was Jerry Frazier a suspect in Amy's death?
I would say yes.
And if you look at page 42, line 22, the question asked of you is, okay, but would it be fair to say you were surprised to hear a state witness say they had conducted cell tower analysis and verified Jerry Frazier's location by cell tower analysis? And then at the top of 43, your answer is, I would have to say that would have been a surprise, yeah. Do you recall giving that testimony?
Yes.
Okay. If you had information that Jerry Frazier was not on the Mullis farm November 10th or near it because of cell phone tower data, would you have still argued that he could have killed Amy?
I think you could, because of the relationship that they had.
Did you consider that?
Hang on, I want to rewind just a second and hear this specific question. And then I have a thought.
The question asked of you is, okay, but would it be fair to say you were surprised to hear a state witness say they had conducted cell tower analysis and verified Jerry Frazier's location by cell tower analysis? And then at the top of 43, your answer is, I would have to say that would have been a surprise, yeah. Do you recall giving that testimony?
Yes.
Okay. If you had information that Jerry Frazier was not on the Mullis farm November 10th or near it because of cell phone tower data, would you have still argued that he could have killed Amy?
I think you could, because of the relationship that they had.
Did you consider that?
Okay, to his point here, right? What does cell tower location in relation to a cell phone actually tell us? Well, it tells us where the phone was. Now, I submit to you, ladies and gentlemen, that the point could be argued. Cell towers and pinning, as it were, pinging, not pinning, pinging only tells you the location of the phone relative to the cell tower, not a person. It's limited. And if you'll recall from George Wagner's trial, we heard evidence that the Wagner family, Jake, George, Billy, left their cell phones back at their house, the Wagner property. So, of course, would they have, if they had picked up, if they had pinged those cell phones to see where they were at the time they think that the murders occurred, what would they find? Well, they would find that the cell phones were at the Wagner house. But that doesn't mean that Jake, George, and Billy were at the Wagner home. We know that they weren't. We know where they were. So that's a problem. So to his point, I think that just based on that data alone, right, it would not take, as a defense attorney, it would not be enough to take Jerry Frazier off the suspect list. But it's also not enough to accuse him in open court.
The state had evidence giving Jerry Frazier an alibi for the time that Amy was hurt.
I don't know.
I want to move on from Mr. Frazier. Do you recall deposing Dr. Kelly Cruz from the state medical examiner's office?
Yes.
Do you recall being asked about reviewing that autopsy report in your 2023 deposition?
I think so.
And what actions did you take after you reviewed that autopsy report to investigate it or to verify the opinions within it?
I don't believe I consulted anybody other than talking to Bob about it, that I recall.
And here's the other issue. Earlier, and I forgot to mention this because I was in the kitchen making delicious pizza rolls, the pepperoni kind with ranch, of course. You can put ranch on everything. Anywho, there was testimony regarding Amy Mullis's items of clothing and whether or not Mr. Jake had viewed those items on his own. And he said he didn't. That's a problem. Even Owens, at the, as late as he came into Sarah, to being Sarah Boone's attorney, still wanted an opportunity to view the evidence, physical evidence himself. And I don't think doesn't mean it hasn't happened, no, but I don't think I can recall off the top of my head a single time that a defense attorney has not wanted to look at the physical evidence.
Do you remember testifying in your deposition that it was your personal opinion that you agreed with Dr. Cruz?
I think it did, yes.
And you don't have any forensic pathologist training, is that fair?
No.
Okay. Okay, I want to talk a little bit about the Google searches that were offered at Mr. Mullis's trial. Do you recall that evidence?
Yes.
Do you recall who testified about the Google searches?
I can't remember which state witness did.
If I told you it was law enforcement, would you accept that?
I think I would, yes.
Okay. Did you do any investigation or take any steps to determine if those officers were qualified to testify regarding cell phone data extractions?
They may have mentioned it in their depositions, but I don't recall specifically.
And did you contact your own digital forensic expert to review the data?
No.
Do you remember testifying in your deposition that the Google searches were harmful to Todd?
Yes.
And do you recall if the Google searches were how the state was using those in their case in chief?
Well, I think they were trying to show that some of the searches were rather specific about harming someone, cheating spouses, that kind of thing.
Would you characterize that as motive evidence?
Sure.
If you had evidence that Todd did not conduct those searches, would you have used that at trial?
Yes.
Do you recall Todd writing letters and having discussions with you about those Google searches?
It came up in letters, it came up in meetings at the jail, phone calls. Yes.
Did you present any evidence in Todd's defense that he did not make those searches?
I recall during cross-examination of some state's witness, and it would have been law enforcement, that there were some obvious searches that, like looking for a dress or something like that, or jewelry, that kind of thing. So I felt that the point was made that not all those searches were done by Todd.
Did you do any work to determine?
Yeah. You made a point that the searches about, dresses he's right. There was some cross-examination questions along those lines, right? But you didn't attack the veracity of the direct examination respective to the, for lack of a better word, what the damning searches, right? The ones that go to motive. You did not attack the veracity of those at all. That's a problem, bro.
Where Todd was on the day of the most offensive searches, the ones that you referenced earlier about unfaithful women?
I don't think so, no.
Do you recall researching or drafting a motion to limit the admission of those Google searches because they were not close in time to Amy's death?
I don't think so.
Did you consider that if searches were being done in May, where Todd would have been at that time?
I didn't try to make that connection, no.
Did you know that your client, Todd Mullis, was a crop farmer?
Yes.
And as a lifelong Iowan, do you know when planting season usually is?
Yep.
When is that?
Depending on the spring, sometimes it's April into May.
Do you recall discussions with your client about his kids taking a hunter safety course?
Yes.
Did you take any actions to determine what that entailed?
I didn't research. I relied on what Todd told me about it.
If we can show the witness 306, but not published. Mr. Firehelm, can you identify the document? Tell me what the name of it is.
It's titled Today's Hunter, Hunter, and down below it says a guide to hunting responsibly and safely.
Do you know what topics a person needs to learn about to get a hunter safety certificate?
No, I don't. I grew up hunting, but I never took a course.
I mean, I don't understand this. Those those internet searches were incredibly problematic if you're Todd, right? And unless the defense takes a step, right? Hold on just a sec. Unless the defense takes the necessary steps other than just listening to their client. Because at the end of the day, yeah, you put Todd on and he said what he said, he testified, right? But you didn't put on any witnesses that could back up Todd's testimony. So if Todd said he didn't do any of the searches, that was like good enough for you. And in your mind, that was enough. And it was going to be up to the jury whether they bought it or not. But you didn't do it. It's like you're building a house and you've got all the walls up, but you have no foundation. Why would you do that? That makes no sense. And I only have a good enough diploma, GED, for those of you who might not be familiar with all my Bendy Lou terminology. But even I know logically you cannot build a house without a foundation. So if you put in this analogy, if Todd Mullis's testimony are the walls and the roof, but there's no foundation, well, it's not going to stay up. You have to bolster your client's testimony. I mean, you didn't know what Todd was going to testify to, didn't you? Okay, here we go.
If you had reviewed this guide before trial and it included information about hypothermia and organs of the body or things like that, could you have used that to explain the Google searches the state presented as motive for Todd to kill Amy?
I think that's reasonable, yeah.
And did you understand that Todd was charged with first-degree murder, which included premeditation or planning, right?
Sure.
If I could show you 223. Do you remember discussing with Mr. Sabers about whether you should hire a computer expert? And I'm showing you an email from May of 2019. If you could tell us when you've reviewed it and identify it for me.
It's going kind of fast, but yeah, it looks like an exchange between myself and Bob and Lynn White.
And did you ever consult with a computer expert or digital forensic expert?
I don't think so, no.
Okay. We can take that one down. Do you remember evidence being tendered to you that included text messages between Ms. Mullis and friends of hers?
Yeah, I think so.
Did you interview any of those friends about those messages?
No interviews, no.
Do you recall deposing some of them?
I think we did, yeah.
Did you seek to issue any subpoenas for cell phone records as part of your defense investigation or preparation?
I don't recall doing that, no.
Do you recall filing a motion in limine before trial asking to prohibit witnesses from testifying to hearsay, especially relevant to the friends of Amy and what Amy had told them about Todd?
I think there was a motion, yes.
Do you recall getting a ruling on that before trial?
Yes.
What was that ruling, if you remember?
Not favorable to our request to limit the evidence.
Do you recall discussing this with Bob Sabers?
Yes.
Oh, I'm sorry, can we show the witness Exhibit 219, an email with Mr. Sabers? Do you recall this email exchange?
Not specifically, but I'm not saying I didn't get it.
If the docket reflects that the judge did not issue a ruling on your motion in limine and reserved it for trial, would you disagree?
Without certainty, no, I wouldn't disagree.
Are you familiar with making hearsay objections during a criminal trial?
Yes.
If you made objections, would those be reflected in the trial transcripts?
Sure.
Do you remember a statement by a friend of Ms. Mullis's, Terry Stainer, to the effect of, look for me in the timber if I go missing?
I remember that specifically.
Was that one of the statements that you intended to address with your motion in limine?
That and others like it.
Why that statement and others like it?
Well, it indicated Amy's state of mind and her fear that Todd would harm her.
Did you consider those types of hearsay statements to connote a guilty inference that you would have wanted to keep out of the trial?
Yes.
Do you recall if you and Mr. Sabers discussed what your roles were going to be at the trial?
I don't recall a specific discussion, but I think throughout it, I was the lead counsel and he was taking notes and making suggestions and talking to Todd and that kind of thing.
Do you recall if he passed you notes during the trial?
He did.
I apologize. Excuse me. Do you recall if you read them?
That's difficult to do during a trial. Glance at them, talk about them during a break, that kind of thing.
Did Mr. Sabers handle any witnesses at this trial?
I don't think he did, no.
Do you recall any discussions about who was going to do the opening statement?
I don't think we ever discussed it.
Did you draft an opening statement to review with your client before trial began?
I normally have, I don't know if you call it an outline or notes, but not really a draft, word for word. And I don't recall sharing with Todd about the content of the opening statement before we went to trial.
Do you remember what the premise of your opening statement was?
That Amy was murdered, but not by Todd.
What evidence did you plan to present to show that?
The focus was on Tristan and his testimony about the events of that morning, of who was where.
Did you have any other witnesses or evidence that you planned to present?
I think we called a couple witnesses that had contact with Tristan after, that took him home from the hospital after this had occurred.
Did you have an alternate suspect or another person in mind that you were going to suggest was responsible for Amy's death?
No, I think I talked about that with Todd and Bob, that it wasn't our job to find out who did it. We just cast doubt about Todd being responsible.
Did your client, Mr. Mullis, ever agree to your decision to make that statement in your opening statement?
I never asked him if I could, and he never told me I couldn't. I think going clear back to early on in the case, I made it clear that I did not believe this was an accident and that she was murdered.
And that was based on your own personal opinion or evaluation of the autopsy report?
Okay, I need to pause for fair use commentary here. This is an issue. This is a huge, huge, huge issue. Because in theory, I agree with Mr. Jake's statement. It is not the defense's job. Hold on. I should have, Siri, nobody is talking to you, lady. Now I said her name and now she's coming back for a second conversation. Pardon me. In theory, I agree with what he said, what Mr. Jake's part of his testimony, right? It's not actually the burden is solely on the state, okay, to prove everything, right? But if you're going to concede during opening statements that, yes, this is a murder, then you might want to mount more of a defense of an alternate suspect other than, well, I mean, Jerry Frazier and Amy were having an affair. So, maybe he did it. If you're going to make a theory, if you're going to have a theory of an alternate suspect, you got to put on some type of evidence of that. I mean, bruh. Like, was this your first trial ever? I mean, maybe you never intended to go to trial, right? Maybe what your plan was based on your review of the discovery that the best that Todd could get was a plea deal and to try to negotiate a plea deal. And your client said, no, there will be no plea deal. I didn't do it. I'm not going to say I did it, and I'm not going to plead to this or anything or any lesser charges. I didn't kill my wife. And then you had to go to trial. Okay. But at the same time, in your earlier testimony, you testified about how long you've been an attorney and all the things. So you should know that you can take, you can make the suggestion to your client, we should go for a plea deal. But you know, as an experienced trial attorney and defense attorney specifically, that there's a 50-50 chance your client is going to be like, no. And your client did in fact say, no, he wanted a trial. And then you should have prepared for a trial adequately, correctly, not just, well, I'm going to put my client on the stand and a couple of his family members, and I'm just going to let the jury figure it out. Like, the jury doesn't know your client. The jury doesn't know his family members, and they're only allowed to base their verdict on what's presented in court. And you know this, man. So come on. Stop playing with these people.
Autopsy report, police reports, life experiences.
And you don't recall writing any letters to Todd explaining that or asking him if he was in agreement?
I'm sure there weren't any letters. Again, we just generally talked about our theme of the trial.
Do you recall that Tristan testified via closed circuit television at this criminal trial?
He did.
Do you recall how old he would have been?
14, I think.
And I think you testified a little bit earlier that part of your plan was to focus on Tristan, right?
Yes, significantly.
Did you consider Tristan to be Todd's alibi?
Yes.
Do you recall there being an issue between Tristan's pretrial deposition and his trial testimony?
Yes.
Did you do any investigation or take any steps to learn more about the slight change in Tristan's testimony?
Okay, so if you were relying on Tristan and his testimony to be Todd's alibi, more or less, then couldn't you have done some independent research to time and take the mean average of a person running from where Todd says that he was in that hog barn to the red shed, and then just average it out and tell the jury how long it would have taken on average for a person to reach Amy? And then to reach that shed, stab her with a corn rake 3 times, run back to the hog shed, and how long it would have taken Tristan to get that drink of water. Just on average, just something.
If I'm recalling the events accurately, Tristan testified in a deposition, and he gave testimony about the amount of time he would have been absent from a location in the hog barn where he could see Todd. And he gave a time frame that was relatively short. And then afterwards, he met with his attorney, and that attorney came back and said that Tristan said he had made a mistake.
And I guess my question is, did you take any action to look into that?
The action I took, and I believe it's indicated in an email, is that I contacted Todd about this development with Tristan and suggested that we needed more time to do that. But Todd was adamant that he did not want to continue the trial. So other than that, Lynn had provided me with some drone photographs of the hog barn and the shed where Amy was found and that kind of thing. So we used those to show the significant distance between the barns. And if Todd did leave Tristan's eye shot, even for the longer time that Tristan said, I think it was 30 seconds, I don't know what, it would have been impossible to leave the far end of the hog barn, go to the shed, do whatever happened there, and then get back before Tristan missed him.
So that covers everything that you did do
Yes.
to corroborate or to investigate Tristan's testimony?
Yes.
Hang on, I was distracted by chat. Because he was testifying pretty much about what I just said. So let me see his answer.
About this development with Tristan and suggested that we needed more time to do that. But Todd was adamant that he did not want to continue the trial. So other than that, Lynn had provided me with some drone photographs of the hog barn and the shed where Amy was found and that kind of thing. So we used those to show the significant distance between the barns. And if Todd did leave Tristan's eye shot, even for the longer time that Tristan said, I think it was 30 seconds, I don't know what, it would have been impossible to leave the far end of the hog barn, go to the shed, do whatever happened there, and then get back before Tristan missed him.
So that covers everything that you did do
Yes.
to corroborate or to investigate Tristan's testimony?
Yes.
Do you recall why you called Mr. Mullis to testify at his trial?
One reason is that so many times when I've talked to jurors after trials, my conclusion was they expect to and want the defendant to testify that they didn't do it, even though you tell them that in voir dire and so forth that they don't have to. And as late as the night before the beginning of the trial, when we met in the Dubuque County Jail, I'm not sure we had decided for sure if Todd was going to testify, but I left that meeting that night with the understanding that we both agreed that he would.
How did you prepare Mr. Mullis to testify?
In those meetings.
Did you ask him questions so he could practice his response?
I don't know if it was questions or answers. We just talked about topics that he would expect to be asked about.
Did you practice any potential cross questions that the prosecutor might ask him?
I don't think so.
Do you remember discussing with Todd that he needed to testify to rebut the Google searches?
I think that is one of the things we talked about, yes.
And was that in part because you didn't have an expert or anybody else to testify about whether Todd made those Google searches?
I don't think that was the reason, no.
Did you cross any other state witnesses about whether Todd Mullis could have done those searches?
There was cross-examination about some of the searches that seemed obvious that Todd would not have done. I can't remember what state witness that would have been.
Did you consider
Right. You cross-examine the state's witness respective to the glaringly obvious Google searches that Todd didn't make. But she's asking what you did to refute the actual texts or searches, that were in question, which is the answer is nothing.
Did you consider Todd's credibility to the jury after your opening statement?
I take that into account throughout.
Were you concerned that you had told the jury that Todd was wrong when he told investigators Amy died in an accident?
Would you repeat that, please?
were you concerned about Todd's credibility in front of the jury when you had told the jury in opening that Todd was wrong when he told investigators Amy fell on the corn rake and it was an accident?
I don't think that comment was undermined his credibility. I think Todd honestly thought that when he said that thing. I just said, as we researched or prepared for trial, that was wrong.
That's not what you said, number one. And so, and then you had Todd up on the stand, and under your direct examination, did nothing to bolster Todd's testimony. I mean, what you did in opening statements was essentially say, my client is wrong about what happened. It wasn't an accident. It was murder. And it's all about who committed that murder. And we're telling you it wasn't Todd. But you didn't even present evidence that of an alternate suspect. So let me just be quiet.
Do you remember the 911 call in this case?
Yes.
Do you remember it stipulating to the foundation or the admission of it at trial?
I think so, yes.
Did you ever take the 911 call to the jail so Todd could listen to it before trial?
I think we had a transcript of it, but I don't ever recall playing the audio for him in jail.
Now, you know dang right well, Mr. Jake, that you cannot hear tone through text. Okay? So, particularly because your argument was, yeah, it's murder, but it wasn't Todd, right? Don't you think it would have been a good idea to let him hear the 911 call? You knew what the state was going to say, not about, him being angry and not actually wanting her to survive. But you didn't ask him any questions about that, like at minute yada 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 whatever where he sounds out of breath. What are you doing right now? And the other thing is, the other thing you could have done with that 911 call, right, is refuted it in such a way, because the state's allegation was that Todd was putting on a performance of a lifetime, acting every bit the grieving and bereft husband, when all along he was the guilty dog. And you could have put on witnesses that would testify to the contrary. You could have at least looked for witnesses that might testify to the contrary and point out in the 911 call that, yes, Todd is clearly upset, and upset's not the right word. Panicky is, I think, a better word. That he's clearly panicky, and there's a sense of urgency. You could have pointed that out, but you didn't.
If you had been tendered a transcript, would that have been in the discovery?
Yeah, I think so.
I'm just clarifying, you didn't have a transcript made.
No, I don't think so.
Do you remember the prosecutor playing the 911 call during her cross-examination of Todd Mullis?
Yes.
Do you remember two comments towards the end of the call that the prosecutor emphasized?
I do.
Had you ever heard those before?
No.
Were those undisclosed statements made by a criminal defendant?
Objection calls for speculation and a conclusion that's well beyond the actual terms of what he can testify to. The evidence speaks for itself.
Overruled. The witness can answer if he's able.
Could you repeat?
Yeah, I'll rephrase. Are you familiar with rules of evidence that require the disclosure of statements made by a defendant?
Yes.
Before the cross-examination where the prosecutor played that call, had those statements ever been disclosed to you before? A purported statement. So sorry.
Well, the whole 911 call was, we always had that, the whole thing. But the contention that he said certain words, no.
And weren't those phrases highly inflammatory?
Yes,
Did you think Todd made those statements on that call?
I did not.
And you don't recall seeing them in any discovery or anybody telling you about them in a deposition?
No.
So if that's the case, that would have been a fantastic time to point out that there is a potential Brady violation. I'm not sure if that's a Brady violation or because it is in, how did she term it? Hold on just a sec. Let me go back a few seconds.
The disclosure of statements made by a defendant.
There you go. The disclosure of statements made by a defendant. I don't know if that is separate from Brady or if it's a subsection of Brady. But regardless, if they pulled those statements off the 911 call, you listened to the 911 call, you didn't hear that, and you also don't recall being told that there were these statements allegedly in that 911 call, then wouldn't it have behooved you to, I don't know, check first to make sure that those weren't disclosed to you? And then based upon your research and investigation into that, if you came up with the fact that they weren't disclosed to you, why didn't you raise it as an issue? I don't understand this. This is utter poppycock. What are you doing, man?
Yes.
Before the cross-examination where the prosecutor played that call, had those statements ever been disclosed to you before? A purported statement. So sorry.
Well, the whole 911 call was, we always had that, the whole thing. But the contention that he said certain words, no.
And weren't those phrases highly inflammatory?
Yes,
Did you think Todd made those statements on that call?
I did not.
And you don't recall seeing them in any discovery or anybody telling you about them in a deposition?
No.
Have you made a motion for a mistrial before in a trial?
Yes.
Did you do so in this case?
No.
Could I have just one moment?
Yes,
Did you think Todd made those statements on that call?
I did not.
And you don't recall seeing them in any discovery or anybody telling you about them in a deposition?
No.
Have you made a motion for a mistrial before in a trial?
Yes.
Did you do so in this case?
No.
Could I have just one moment? Do you recall the prosecutor telling you off the record that she was going to ask him about these specific statements?
I'm certain that she did not.
Do you recall taking any investigative steps to determine who would have been present at the time of those alleged or purported statements by Todd?
If I'm remembering correctly, the 911 call ended there on the gravel road when law enforcement and, well, first it was law enforcement people showed up. And that's about when supposedly he made these statements that the prosecutor brought up.
If you had notice of these purported statements, could you have investigated or attempted to discredit that cross-examination question?
Yes, I I actually took the 911 call after the trial was over and had it enhanced to try to see if I heard what supposedly was said.
Did you ever learn how the state came to make that argument?
I was told by the prosecutor.
Did you get your own transcript of the call for post-trial motions or anything?
Because of the change in representation, I wasn't involved in the post-trial motions.
When did your representation end? I should have asked you that first.
Between verdict and sentencing.
So you did not get a transcript of the call before your representation ended, am I right?
I think you're right. I'm not sure we ever had a transcript of it.
Your Honor, can I have just a moment to confer? May. Nicole, can you find 294 to show Mr. Firehome? And I'll move on for a moment and come back while you're doing that. I don't think I warned her I was going to do that. Mr. Firehome, during your 2023 deposition, do you remember being asked about a Greeley EMT who had filed a report about her response to the 911 call for Amy's injuries?
Yeah, I recall something about that, yes.
Did you do any investigation or take any steps to determine whether the first responders' actions and or CPR could have caused some of Amy Mullis's injuries?
I vaguely recall whether it was the ER doctor at the hospital or possibly during the medical examiners, but I'm not sure of that. I'm sorry.
Did you talk to any of the Greeley EMS first responders before trial?
No.
Do you recall the Mullis family telling you that Greeley EMS was there and that you could contact them?
I don't recall them telling us that. It was pretty obvious from the reports. They might have.
But did you ever do any follow-up to get the Greeley EMS reports before trial?
Not unless they were in the general discovery.
Did you ever learn that law enforcement was suspicious about how Amy sustained her injuries at the hospital on November 10th?
I honestly can't say when the suspicion began.
Do you recall doing any investigation or interviews with people about that?
Again, and I might be wrong about this, about whether or not that hospital doctor talking to the law enforcement, that it may have started then, the actual
But
day.
did you take any steps to learn about potential conflicts of interest or bias in the investigation?
No.
And were you aware that Amy Mullis had worked at the same hospital where she was taken when she was injured?
Yes, I think we did know that.
And were you aware that some of the witnesses the state called to elicit those hearsay statements worked at that hospital as well?
I think we were aware of that, yes.
Are you ready, Nicole? Okay. 294. With the record to reflect that we're showing the witness exhibit 294. And if you could take a look at the first page and tell me what it is, and then we are happy to scroll through it for you.
It's still dark.
Still loading. It knows that it's 4 o'clock, I think.
Yeah, I'm not showing it's connected. I'm not sure.
I mean, these are all things that should have been done. That's it. That's all.
Sure, if you need to try again. All right, let's try that one.
The date of the call?
Yeah.
The date of the call?
Yes.
November 10th, 2018.
And does it identify who made the call?
911 call by Todd Mullis.
And if we can start scrolling. Page 15 of the PDF. Could you review that for me, Mr. Farrell?
Yes.
I want to direct you to line 5. Can you read that for me?
Deputy Luke, here, comma, Todd, let me.
Do you know who Deputy Luke is?
No, not specifically.
If I told you that was Delaware County Sheriff Deputy Luke Thompson, who testified at trial, would you disagree?
No.
Objection. We're reading from a transcript, not an evidence that the state would object to its admission and consideration of in the first place.
If I could ask 2 more questions, and then I'll move to admit it, Your Honor.
Well, again, if there's an objection to it, we should probably admit it before we get too far in the weeds. I mean, do you think you can get it in through this witness?
Probably not.
Just a moment. Your Honor, it's a certified transcript by a court reporter. I'm not sure what other foundation the state would like to have. Page 17, I think, is where Kimberly Blink does her certificate.
I mean, counsel, any response in that respect?
While we agree that this is a certified transcript of a 911 call that, according to that same certification, is done merely to the best of the court reporter's ability, based upon heavy breathing and inaudibility, this is not a transcript from a court proceeding. It constitutes hearsay. This witness hasn't seen it before, and while it's certified, that may go to its authenticity and to its identification, but it certainly doesn't go to its admissibility outright. So the state objects on lack of foundation, objects also on hearsay, as it falls under the rule and doesn't meet any criteria or exception. And 403(2)B as prejudicial more than probative, given that the Court of Appeals have already addressed this, and a footnote finding that the jury could listen for themselves and believe or disbelieve the arguments of the prosecutor as presented at trial.
Well, I think that certainly, Ms. Nichols-Cook, you can ask your questions about the timing and the presence of the deputy in relation to when these statements were made or not made without the use of the transcript. We can address the possibility of this coming in maybe at a later time. I don't think this is the right witness necessarily to do it if it is going to come in, but why don't you proceed? We do need to end at 4:30 today, and I suspect we're not in a position to do that, so go ahead.
Okay. Thank you, Your Honor. Mr. Fireholm, if you could just read through page 15 and 16 for me.
You can just tell me when to scroll.
Page or line?
Page 15 and page 16.
The whole page, bro. The whole page.
Oh, okay. It's kind of covered up, but I think this is 15. Line 2. Oh, excuse me.
Just
tell me when you want me to scroll since I'm helping with the technology.
Could you let me see the top?
No, sure.
Okay. That's good. Line 2 starts out, she's cold.
And right now, you're just reading to yourself, sir.
Oh, I'm sorry. I'm sorry.
Oh my goodness. Okay, now I would expect that confusion from a lay person, right? But not a trial attorney. Yikes.
Scroll, please.
Have you been able to review page 15 and 16?
Yes.
Okay. In your review of this transcript of the 911 call, do you see the 2 statements the prosecutor asked Mr. Mullis about on his cross-examination?
I do not see those words.
Thank you. We can take it down. Mr. Firehelm, are you aware that the state misrepresented the source of the Google searches at the criminal trial?
Objection to the categorization of the state's statement, and also under Rule 5403B. Also vague.
Sustained.
Mr. Firehelm, I'll ask a different question. Are you aware that evidence exists that would have rebutted the evidence presented at trial that Todd Mullis alone made the Google searches that the state presented?
I'm not aware of any technical research or document.
Are you aware of digital forensic experts that could examine the iPad and determine information that could potentially contradict the evidence presented at trial?
Well, that's pretty broad. Yeah, I assume an expert could examine it and give an opinion to that. Whether or not it would confirm it or not, I don't know.
If there was evidence that contradicted the state's presentation about the electronic evidence, Would you have used that at trial?
If there was evidence?
Yes.
Yes.
If you were aware of evidence that contradicted the state medical examiner's determination that the manner of death was homicide, would you have presented that at trial?
Yes.
Okay, I think I have one last exhibit to show you, which will be 245. Oh, yeah, sorry, no. 245. Mr. Farnham, do you recognize the document on your screen?
No.
If we can scroll a little bit, and let me know if you do recognize the handwriting or content.
I don't know.
Okay. We can take that one down. Do you recall taking any steps to investigate Amy Mullis's medical condition at the time that she was injured on November 10th?
We were aware that she had had a medical procedure a few days prior.
Did you obtain medical records about Ms. Mullis's procedure or medications that she was on?
If it was in the discovery, yes. I don't recall specifically.
Did you do any investigation into whether Ms. Mullis would have been dizzy on November 10th due to her medications?
No research, no, other than what Todd and Tristan said.
And did you issue any subpoenas to get medical records?
I don't believe so.
Did you have any medical records that you did receive in discovery reviewed by an expert?
No.
Do you recall a letter from Mr. Mullis asking you to, or stating that he wanted to get a 3D demonstration of the injury to show that it was a fall?
No, I don't recall that specifically, no.
If we can pull up 233. And we're going to go to page 11. 233. 233. Is it in front of you, Mr. Farrell?
Yes.
Can you read page 11 and 12? Do you see any drawings or diagrams in this letter?
It's not very clear, but I can tell that there's something there.
Look at page.
But that one, yes.
We can scroll to page 13.
Your Honor, I'm going to object. This exhibit isn't in evidence. It's hearsay. It hasn't been adequately authenticated. I do believe 213 was admitted into evidence, and 233 was admitted in full at this time. I apologize. I withdraw my objection, Your Honor.
Thank you.
Mr. Farnham, have you had a chance to look at page 13?
Yes. Excuse me.
And we can scroll to 14 as well. Do you see additional drawings regarding Amy's injuries in this letter from Mr. Mullis?
I do.
Did you take any steps to investigate the information that Mr. Mullis provided to you?
I don't know what the date of this is.
Do you recall taking any steps at any time to investigate the information in this letter?
No forensic experts or witnesses or anything, no.
Okay. Your Honor, I think this is a good place for me to stop. Unfortunately, I think I still have a few more questions for Mr. Fireholm. I don't know if the state would be agreeable to, I think we have potentially an expert in the morning, and Mr. Fireholm might not be able to get back up here until tomorrow afternoon.
And maybe we can have some.
Okay. So it sounds like there'll be more testimony of what's shaping up to be a clear ineffective assistance of counsel claim. So this is where I leave you guys for today. I will be back tomorrow morning bright and early. I have a little recap I want to do with you guys, and then we'll get started on day 5's testimony. Sound like a plan? Now, if during day 5's testimony includes the lawyer, we're going to start with the lawyer first and then go backwards, because I want to hear the testimony in order, because I feel like that is better. But anyway, I want to thank you guys so much for being here today. Thank you for your support. Thanks for the great chat. If you could do me a big, huge favor and give me a thumbs up on the stream, or a thumbs down if you think I deserve it, either one, whichever. I leave it to your judgment. I would appreciate it, and I will see you guys tomorrow. Have a great rest of your day. Bye.